Good morning, President. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Belize, hearing of appeals and cross appeals in CCJ appeal BZCV number 4 of 2025 between Belize Tourism Board and Misty and CCJ appeal BZCV number 5 of 2025 between Belize Tourism Board and Karen Bevans. The members of this morning's panel are Mr. Justice Anderson, President and the presiding judge.
Good morning, Counsel.
Madam Justice Rajnos Lee.
Good morning to everyone.
Mr. Justice Jamadar.
Good morning to everybody.
Madam Justice Ononewu.
Good morning, everyone.
And Mr. Justice Ebo Suji.
Good morning, all.
Counsel, may we have the appearances, please? Thank you.
May it please the court, Amon Courtney appearing with Ileana Swift for Belize Tourism Board in both appeals.
Thank you, Mr. Courtney. And for the respondent? You're muted.
I'm sorry, I'm muted. Forgive me. Mr. President and Your Honors, Dean Barrow, together with Mr. Nigel Ebanks and Ms. Darinka Munoz for the Belize, for Mr. Michael in the appeal between the Belize Tourism Board and Ms. Michael.
And I may have missed it, sir, but do you also appear for Mrs. Bevans?
Yes, indeed. Yes, indeed, Mr. President. I thought we were dealing with them seriatim and that we were just recording appearances with respect to the Mr. Michael appeal initially. We had agreed on the last occasion that they would be done separately, that there was no consolidation. And so that is why I proceeded in the way I did just now.
But did we agree on the order in which we would hear the appeals?
I don't think we did, but I thought that since the Michael appeal was first in point of time, that logically enough, that is the one we would begin with.
Okay, thank you very much. Thank you for the appearances, Counsel. So I think Mr. Barrow has put his finger, if I may say so, on a point that we need to be clear on at the outset, and that is how the appeals will be presented to us this morning. We had agreed that there would be no consolidation of the two, and instead we would hear them on the same day. So I do believe Mr. Barrow is within his right to indicate that he wishes a bifurcation of the appeals and that we treat with one entirely and then the other. I gather that is your position, Mr. Barrow?
Indeed, Mr. President.
Very well. Do you have any objection to that, Mr. Courtney?
May it please the court, Your Honor, I believe you would have seen from the submissions that insofar as the cross appeals are concerned, they are virtually word for word repetition of the Mr. Michael and the Karen Bevans. We have taken a position, quite frankly, Your Honors, that we propose to deploy submissions on the law with respect to the Bevans appeal, and we have asked the court to apply those submissions of law to the Mr. Michael appeal. I had intended to indicate to Your Honors that I am content to rest on the few words that we have said in the Mr. Michael appeal, and I do not propose, unless asked by the court, to make any submissions in respect thereof, oral submissions.
Very well. So, Mr. Barrow, then that would accommodate your understanding as to how we approach this matter, with the suggestion, as I think is implied in what Mr. Courtney just said, that you would hear the Bevans appeal first. Would you be objecting to that?
Yes, Your Honor. I thought I just indicated that in my respectful submission, the Mr. Michael appeal ought to be heard first, since that came first in point of time. And while Mr. Courtney is saying that he does not propose to offer any oral presentation regarding the Mr. Michael appeal, I certainly want to speak on the Mr. Michael appeal. He, as he said, did submit very brief, very economical, if not laconic, written submissions regarding the Mr. Michael appeal, and I would want a chance to address the written submissions that he has filed.
No, I don't think there's a difficulty with that. I think the issue has to do with the order in which the appeals are in fact heard. And subject to what Mr. Courtney says, I think it may have been a bit more convenient if we heard the Bevans appeal first. He deploys the arguments which are indicated in his written submissions. We then go on to hear the Michael appeal, at which point he would not have very much of anything to say, having said all he wanted to say in the Bevans appeal. We did not in the order indicate how we would start. I do take your point about the appeal being filed first in time, but would it inconvenience you greatly if we started with the Bevans appeal?
I think it would.
It would.
Quite frankly, Your Honor. I believe that there are material differences between the two appeals, and I would like a chance to address frontally, head-on, the Mr. Michael appeal, first in point of time, because I think that would then make it much less convoluted when we come to the Bevans appeal to try and kind of roll up the submissions. If it's all the same to the court, I really would beg the court's indulgence, beg the court's leave. I really am fixed on the notion that the less complicated, if I might put it that way, of the two appeals is the Mr. Michael appeal, and it's first in point of time. And I believe we can deal with it with dispatch, much greater dispatch than would be the case regarding the current Bevans appeal.
Very well. So I understand you fully, Mr. Barr. Just to confirm, however, you are prepared this morning today to argue both appeals.
Yes, Your Honor.
Is just that you'd want the Michael appeal to be argued first?
Yes, Your Honor.
Very well. Mr. Courtney?
Mr. President, Your Honors, the appeals before you this morning are brought by the Belize Tourism Board. As the President has pointed out twice, there was no order as to the order in which the appeals would be presented. I would be deeply obliged if the court would permit the Belize Tourism Board to present the current Bevans appeal first. As I indicated in my written submissions, and as I said a short while ago, with respect to the Mr. Michael appeal, we propose to rest on what we have submitted in the Bevans appeal. To the extent that my learned friend wishes to make certain submissions on the Mr. Michael appeal, of course, he's entitled to do so after we have deployed our arguments in the appeal. But, Your Honors, I do not wish to detain the court any further. If Mr. Barr wishes to make some points on the Mr. Michael appeal at this stage, I'm entirely in Your Honor's hands.
Yeah, but what you do, I gather, is to reserve your position such that you could make any arguments in rebuttal, if that is necessary, when we get to the Bevans. Is that what you're proposing?
Indeed, Your Honor.
Very well. Does any of my colleagues wish to see clarification on any point? If
President, only
Yes.
that it would be a little odd if the appellants have courage of this appeal, that we start hearing the respondent in one of the appeals. I it may.
Yes, I gather that Mr. Courtney would nonetheless wish to make some brief cursory remarks in relation to the Michael appeal. Maybe simply to say that he would be relying on the arguments in this case that he will deploy in the Bevans appeal.
That is correct, Mr. President.
That is correct. So I would suggest, colleagues, that we take a very short break, that we consider the issue that is before us, and then come back to council with a decision as to the order in which we will hear the appeals. There is another matter that we could probably take now before we come back, and that is that it appears that there was some non-compliance by counsel on both sides with the order of the court issued on the 30th of January as to the length of the written submissions. As I recall it, the order ordered that the written submissions ought not to exceed 10 pages for the appellants as well as for the respondent. In the case of the appellant, the excess went by 10 pages, i.e., number of pages submitted was 20 pages rather than 10, which had been ordered. And in the case of the respondent, the excess was 8, that is to say 18 pages were submitted instead of the 10 ordered. I also understand, Mr. Courtney, that in your reply, you were not able to confine the reply to 5 pages, but rather went to 16 pages. Similarly, that's in the Bevan case. In relation to the Mitchell case, because of what we said earlier, Mr. Courtney, you were well you came in under the 10 pages. I think you were 1 or 2 pages. Whereas the appellant the respondent, I'm sorry, went up to 15 pages. So that is how we have seen it. I don't know whether we have seen it right or you wish to correct the record as we understand it.
Mr. President, I specifically recall pleading for more pages when we had the case management. And if I recall, Mr. Justice Jamadar pointed out that we had the 2 appeals and the law would probably be just about the same. And so I said, well, I can share the pages without repeating in either one. At that time, I wasn't sure which one it would be. So the position that we took was that we had an aggregate amount, and I would use as many pages as I needed in one appeal and then just file 1 page in the other. That's my recollection. It was never intended by us to exceed the order, the number of pages.
I hear Mr. Courtney, but even so, the submissions you made in Bevans was 20 pages long. And in the Mitchell case, I think it was 1.5 and 2 pages. So even if you aggregate that and divide by 2, you're still over, maybe by a page or so.
Your Honor,
yes.
With respect again, in the Bevans one, we end at page 20, but that includes the front page, which I suspect is not counted.
I see. So, and then in the Mitchell one, you're saying it's 1 page, basically.
Yes.
So that's 20 divided by 210.
Yes.
I see. Very well. How do you account for the reply, which went to 16 pages?
So we got 16.
Mr. President, I plead guilty.
And throw yourself on the mercy of the court.
Yes.
Very well.
I apologize.
I think we might need to exercise that measure of mercy, because there is a provision in Part 12.3 is it, I'm sorry, it's 8, it's rule 8, which indicates that where a party fails to comply with any order or direction given by the court may impose any sanction, including dismissal of an appeal or cross appeal that the justice of the case requires. So, Mr. Barra, sir, what say you?
I will don ashes and sackcloth so that I will associate myself with Mr. Courtney's guilty plea.
Yes.
I apologize. All I can do is to say to the court that I will seek to make amends by staying well within the limits for the oral presentation.
That is wonderful. And since I wouldn't say that we have you in the crosshairs, but since we have the advantage, I'm sure you'll not opine too violently in relation to the order we decide to hear the appeals, given that we have the power to dismiss the appeals and the cross appeals because of the non-compliance with our rules. Mr. Barra?
Your Honor, I don't want to sound extreme, but basically in these matters the court is omnipotent almost, and whatever decision the court makes, that's it. There's
including the
nothing
order in which you will hear the appeals.
Yes, I do want to stress that there's a particular reason why I feel that the Michael appeal should come first. I believe we can get certain matters out of the way, and they would not then need to trouble us in the course of the Bevans appeal. But ultimately, it is whatever the court decides.
Wonderful. Thank you very much, Mr. Barra, Mr. Courtney. We will adjourn for a short while, no more than 5-10 minutes at the most, and then rejoin you. Madam
Thank you.
Deputy Registrar.
Court adjourned. Thank you. The Judicial Council will take you to a space.
Thank you. Just awaiting the appearance of my sister.
Justice Rochnatley, yes, I'm not seeing her on as in precedent. Thank you.
And are we seeing my brother, Justice Jamada?
Yes, yes, yes.
Wonderful. Yes, excellent. Thank you. Thank you, Counsel. So we have considered the issues raised. First point to note, I hope your relief, is that we will not dismiss the appeal or cross appeal for failure to comply. Instead, we will simply issue an admonition for future conduct. Secondly, we have agreed that the Misty and Mr. Michael appeal will proceed first. We have had reference to the order, as Mr. Barr indicated, in which the appeals were filed. Take a note of what Mr. Courtney has said in response. However, we have such confidence in the ability of counsel on both sides to be flexible and to present their arguments that we thought that we would proceed as it had been indicated by the order in which the appeals were in fact filed. So that said, we're going to proceed then with the Belize Board against Misty Mitchell, and to indicate to the appellant, Mr. Courtney, that he has, as I recall it, 45 minutes in which to make his submissions in this case, in this appeal, and a further 20 minutes in reply should he wish to make use of those 20 minutes. Mr. Courtney, please.
May it please the court. Thank you very much, Mr. President, and your honors, and we stand admonished. Your honors, it is a respectful submission of the Belize Tourism Board. One, that the appointment of Ms. Michael was ultra vires as being contrary to Section 14 of the BTB Act. Two, that contract of employment was not binding on the BTB, and therefore it could not, being ultra vires, it could not be cured by acquiescence or estoppel, and therefore it ought not to have been enforced. Those are our submissions in support of the Michael appeal.
Thank you, sir. Any questions from my colleagues? There being none.
President, if
yes,
I may. Yes,
of course.
Mr.
Yes.
Courtney, please. I am looking at a speaking note that you filed in the Karen Bevans matter. Did you file a similar one in Misty Michael? If you did, I missed it. I'm sorry.
I did not, Justice Rochnatley.
Yeah, and in your introduction to the Bevans matter, you mentioned your challenge of the additional award. Is there any similarity at all in the Misty Michael matter?
There is no such similarity.
Okay. I just wanted to get clarity on that. Thank you very much. Yes.
Right.
Thank you.
Very well. Thank you, Judge. Mr. Barham, sir, again, you have 45 minutes, please.
Thank you. I propose, with the leave of the court, to spend maybe 20 minutes on the response to the appeal. And if that is the way the court will treat it logistically, I would then ask my associate, my junior, Ms. Munoz, to address the court on the cross appeal. So I would handle the appeal proper, and Ms. Munoz would handle the cross appeal, if that meets with the court's approval.
It does. Thank you.
In terms of the appeal, Your Honor, one of the reasons I wished that we deal with this first is because I want to take what is not quite a preliminary point, but a position that respectfully, if I'm right, ought to dispose fairly easily with the appeal. If the court looks at the appellant's written submissions, which are extremely brief,
Yes. They are.
they list three positions. One, the decision to appoint as being the gravamen of the appeal. One, the decision to appoint Mrs. Michael as Director of Marketing and Industry Relations was made by the then Minister of Tourism. There is no evidence that the board of the Belize Tourism Board decided to appoint her to the post. In short, there was non-compliance with sections 8, 12, and 14 of the BTB Act. Your Honors, it is our position that the appellant can't be heard on this point because it was not a ground of appeal. We submit that the appellant is bound by its pleadings and that this is therefore out with the permissible scope of the appeal that he has lodged. If your honors will recollect, beginning with the matter in the High Court, we took the point that Mrs. Michael was terminated under clause 7.13 of her contract of employment. The letter of termination that she was written, in fact, advanced clause 7.13 as the basis for terminating her. If the court will recollect, 7.13 was a provision that said, in effect, if the BTB found itself cash-strapped, found itself in straitened financial circumstances to a degree where, as it were, it made it impossible for it to continue to pay its employees under the contract that Mrs. Michael and other heads of department had. It was entitled to terminate. And to repeat, in writing to Mrs. Michael to say we're terminating you, the board said we are doing so under 7.13 of the contract. Mrs. Michael then sued for wrongful termination on the basis that the clause 7.13 was not properly satisfied, and she led evidence that the circumstances, the financial circumstances, it was COVID, but the financial circumstances of the BTB were not such as to make it impossible to pay Mrs. Michael. The BTB's defense at first instance was that no, given the fact that the Belize International Airport was closed, that there had been a complete drying up of the tourism flows. Indeed, the financial situation was so dire that it could properly take advantage of the particular provision. That was its defense. It was only at the end of the defense that for the first time, the BTB introduced a counterclaim, praying for a declaration that indeed the other clause, I'm sorry, for a declaration that the contract itself was illegal because it was not in compliance. It was not made in compliance with the provisions of the Belize Tourism Board Act. I repeat that in front of the learned trial judge, we said, but this is not possible. You can't approbate and reprobate. You are bound by your election. And since the basis of the dismissal letter was a clause under the contract, you were treating that contract as valid. And it was not until you came to pleadings or came to your defense that you appended this counterclaim, which for the first time raised this issue of the invalidity of the contract.
Mr. Barrow,
yes.
Mr. Barrow,
Yes,
is the point you're making, is it that the claim of non-compliance with the statute as a basis for termination was a subterfuge. It was not a real motive for the litigation. Is that the point?
In effect, it was impermissible. It was impermissible, and it was only as a kind of, if not a subterfuge, as a kind of fallback position, as fail safe, because of course the issue had been well and truly joined as to whether under 7.1.3 the circumstances justified.
Are they entitled to a fallback position? Are they not?
No, they weren't, in all respectful submission, because they had affirmed the validity of the contract by relying on the very contract and clause 7.13 of that contract as the basis for terminating Mrs. Michael.
Mr. Barrow, did the High Court rule on your point? Did they
What
rule?
the High Court, yes, thank you, Mr. Justice Chairman. What the High Court did was to say, well, in any effect, your argument that the entire contract was invalid because there was no evidence to show that the minister had approved the making of the contract was not anything that the evidence supported. The BTB was not able to introduce any evidence. It made, it deployed this position, but was not able to justify it. So in effect, the learned trial justice got around it by saying it's not on. The learned trial justice, the learned trial judge did not in fact say, look, you have made an election and you're bound by that election. You cannot now come and introduce.
So the trial judge ruled on the argument of the invalidity, but rule against them.
Yes, yes, yes.
What you are suggesting is that it should have been a non-issue. That's why you started by saying, well, it's a preliminary point, but not quite, because a preliminary point can, as we know, it can be dispositive. I think you are suggesting to us that what you were trying to tell the trial court judges, look, this is dispositive. They can't approbate and reprobate, right? But the trial judge didn't agree with you then. Trial judge went on to entertain it and ruled on it, but heard the second point, but then they failed. What did the Court of Appeal do? What did the court? Did you raise it again before the Court of Appeal?
Yes, yes, sure.
And what did they do?
What the Court of Appeal did was, in fact, if I could take the court to the judgment of the Court of Appeal, which I believe is tab 2 of the Record of Appeal, Volume 1, there is some confusion in the tabs listed on what is stated in the document I have in front of me as Record of Appeal, Volume 1. But that says that that Record of Appeal contains tabs 1 to 23. And if the court will look at tab 2, that is page 7 of 36.
Can you tell us the paragraph in the Court of Appeal's judgment that you want us to look at?
I would ask court to look at, first of all, the paragraph, starting at paragraph 4, where the Court of Appeal sets out the background. On 19th August, Mrs. Michael was hired by the BTB as head of the department, etc., etc. And then at paragraph, at paragraph 6, the Court of Appeal set out what 7.1.3 said. And then at paragraph 7, the BTB in its amended defense denied the claim and asserted that Ms. Michael was terminated pursuant to clause 7.13 of the employment contract following the shutdown. And then at 8, further or in the alternative, the BTB claimed that the employment contract requires payment of a sum that was well in excess of the total value. And at 9, and this is what's, I think, extremely important, the BTB counterclaimed for a declaration that the written contract of employment dated 1st April 2020 made between Ms. Michael and the BTB is invalid and unenforceable, as neither her appointment as Director and Head of Department of Marketing and Industry Relations nor her remuneration was approved by the Minister in violation of Section 14.2 of the Act. Now,
so this is just setting out the arguments by both sides. But I think what my brother asked was, how did the Court of Appeal actually deal with this issue?
Well, it went on to, in fact, consider the argument of the BTB as to invalidity and unenforceability as a consequence of this argument that I'm sorry.
I'm sorry. 1 second. I think somebody's mic is on, which is causing a disturbance. So if you're not actually speaking, perhaps it's best to just mute the microphone. Mr. Barrow.
Yes. It did go on to consider this, and in all respectful submission, it was quite wrong. But there's more to it than that even.
Mr. Barrow, before you go on to the more, does the Court of Appeal address a similar submission as the one that you are making before us? And if so, point us to the paragraph where they say, for example, counsel for Misty Michael submitted. Is there such a paragraph here that we could look at to see what your argument was before the Court of Appeal and how they dealt with it, which I think is the question that Justice Jamada was trying to get at?
I don't see where it addressed it frontally. It did deal with the appointment process at paragraph 16 under section 14.2. And it was that appointment process that, in fact, the BTB had challenged in the court below as a way of arguing that the entire contract was invalid. But what I find is very important is when the court comes to look at what in the judgment of the President of the Court of Appeal appears on page 7, page 13 of 36, ground 1. When the President was recapping the grounds of appeal that were before the Court of Appeal, it said, ground 1, whether implied requirement for prior approval of the minister to be made in writing. That was really the essence of the argument deployed by the BTB below, that there was not compliance with the statutory requirement for approval of the minister to be given, the board said, in writing before there could be any appointment of Mrs. Michael. And your honors will see that the Court of Appeal said at paragraph 13, the BTB argued that the trial judge erred in her decision at paragraphs 22 and 23, that there was no requirement for the minister's approval of the terms of the employment contract to be evidenced in writing, and therefore she accepted the evidence of Mrs. Bevans that the minister gave his approval. The trial judge at paragraphs 22 and 23 stated, and she quotes 22, Mrs. Bevans also testified that the contract of Ms. Michael was put to the minister for approval and that it was put to the chairman of the BTB. She testified that she told the minister what the terms were and that his approval was given to proceed. According to her, the minister's approval was verbal of the claimant's appointment and contract. I found Mrs. Bevans' testimony on a whole to be clear, measured, and convincing.
Mr. Barrow, that is going to whether or not questions of waiver or acquiescence and estoppel could arise on the facts. But you are submitting to us, as I understand it, a clear and simple point that this appellant in this appeal is not competent to raise the invalidity argument that it advanced below and in the Court of Appeal because the ground of termination was on 17, is it 13? I forget now. 17713 of the contract, and therefore they have acknowledged the validity of the contract. Is that not your submission in law before us?
Yes, indeed. Yes,
well,
indeed.
all right. Right, all right. So you say that as a pure question of law, this appellant is not competent to raise that.
Yes, but I say more, Your Honor.
Yeah.
Because I say that when the court looks at Mr. Courtney's written submission, the court will see that at 1, he says, the decision to appoint Mrs. Michael as Director of Marketing and Industry Relations was made by the then Minister of Tourism. There is no evidence that the board of the Belize Tourism Board decided to appoint her to the post. In short, there was non-compliance with sections 8, 12, and 14 of the BTB Act. That was not the appeal before the Court of Appeal. The appeal was not that the appointment was made by the minister and not by the board. The argument was that the minister had failed to give his approval in writing. So again, as matters proceeded, the appellant, I'm afraid, kept switching horses in midstream, kept colloquially moving the goalposts. And if your honors look at that one of Mr. Courtney's submission, the decision, this is his ground that he's now bringing before your honors. The decision was a decision made by the Minister of Tourism and not by the board. But that was never the appeal. Apart from the question of whether the appeal as it was ought to have been countenanced by the Court of Appeal, the larger issue is, well, but for argument's sake, if it was, that is not what is now being raised. What is now being raised is not the ground that was before the Court of Appeal, because that ground, as it is stated by the President, ground one, whether implied requirement for prior approval of the minister was to be made in writing.
Right. I think we have you very sound on that point. Actually, 2 points, Mr. Barrow. Of course, the appellant raises 4 grounds, perhaps 3, that he proposed to rely on the appeal before us. So that's with the first one. Is it your intention to deal with the second and third?
Well, I will accept that in my respectful submission, if in fact ground 1 is not competent to be raised, because my learned friend is bound by the pleadings, by the notice of appeal, and by what was put before the Court of Appeal, then it strikes me that that's the end of the matter. But
well, he's saying in ground 2 that the chairman and vice chairman did not have ostensible authority to enter into the contract of employment with Mrs. Mitchell. So is that an independent ground from ground 1?
Well, I think it's related, because he's saying, Mr. President, that in fact, the decision was not made by the board at all. And if he can't say that, and if therefore it is conceded that on the face of it, the decision was made by the board, then there can be no question of the vice chairman and chairman not having ostensible authority. On the facts as we argue them, the decision was made by the board, and the argument being raised so very belatedly that it was not raised by the board is not competent to be raised, and that leaves us with the default position, which is that there was an appointment made by the board, and so the question of whether the chairman and the vice chairman had ostensible authority does not arise, because there's no need for ostensible authority if the board proper made the contract, signed, signified by the hand of the chair and the vice chair. But once my learned friend is out of court with respect to this first ground of appeal, once in the absence of any argument showing otherwise, it is accepted, it is not challenged, that the decision to appoint Mrs. Michael was made by the board. That's dispositive.
Very well. What about ground 3? Because that would appear to be independent of the question of the validity of the contract. Ground 3 having to do with whether clause 7.1.1 was in fact a penalty.
Oh, yes. Well, Your Honor, I would say that if my learned friend, if the appeal in terms of challenging invalidity of the contract is ousted altogether, then part of that ouster is the argument concerning whether that clause is a penalty. That's the first thing I would say. I would go on, though, to argue that if I'm not right, it is not a penalty because of the modern approach to the question of penalties, as was enunciated in Cavendish and in other cases. And the fact is that in the circumstances here, the evidence showed that there were several several contracts of employment made. In fact, in one fell swoop, 5 were made because of a decision taken by the BTB to, in its view, better secure the services of the senior managers, the marketing manager, the finance manager, that sort of thing. So there's no question of disproportion. The fact that this was as a consequence of an agreement under the freedom of contract, under the freedom to contract, on both sides, on both sides, is such, in my respectful to Your Honor, that the court will assign great importance to that fact, the freedom of contract. And it is very difficult to see how the argument that Mrs. Michael was unfairly privileged, that there was excessive compensation, can hold, given that there is evidence as to why, as to the rationale for going this route, and the fact that it was done in one fell swoop for like 5 officers, and that there was a long-standing practice of the BTB to try and secure senior managers, bind them to the company for a fixed term by offering them this sort of a compensation package.
So the offer of the compensation, of course, related not just to the wages, salaries, but also to the benefits. But you're saying that this is fairly standard practice for the BTB.
The evidence is there that there were.
Were there any comments made on this, Mr. Barra, in the courts below about whether this sort of clause was standard?
Yes, yes, both at the High Court and at the Court of Appeal.
Yes. Okay. Very well. Thank you. Now,
President, before we move on, Mr. Barrow, on that point, is there a difference between something not being unusual versus the thing being a standard? And does it matter?
I think there is. And I think in this case, the facts show that it was standard. It was not that it wasn't unusual, that it was standard. It was standard and of antiquity. Well, antiquity is perhaps too strong a word, but it was a long-standing practice of the BTB stretching back over a number of years.
It was a custom. It was a customary to see that and the BTB.
Yes, Your Honor.
One question of fact: is it the case, unlike the Bevans case we'll go to next, is it the case that Ms. Michael was in her first contract? She was not being renewed.
No, she was in a second contract, but her original contract
Is it different?
was of a different genus completely. She was under that arrangement a permanent employee of the BTB, governed by the manual, governed by the handbook. This was a sea change in terms of this transition to this fixed term contract.
Thank you.
Thank you, Judge. Mr. Barrow, I think you went a little bit longer than you had anticipated. I think you went
My
for
apologies,
half an hour.
my
No, that's fine.
apologies.
But the consequence of that is that your co-counsel then has another 15 minutes to make the arguments on the cross appeal.
Thank you, Your Honor. I will mute my mic.
May it please you, Your Honors, we maintain the position expressed by senior counsel. And these arguments are merely alternative. The main position being that the issue was not taken by the BTB in the lower courts, that the decision maker was the minister instead of the board, the Belize Tourism Board. So there are three main points that we take in the cross appeal. And those points relate to the alleged procedural defect found by the Court of Appeal in the appointment of Ms. Michael. That's the first point. The second point is that the Court of Appeal found in any event that the chairman and vice chairman did possess ostensible authority to bind the BTB. And the third point that we take is what we refer to as the Warrington point. And these are all in alternative, because if the main position taken by senior counsel is accepted by this court, then those other points need not be considered. However, we do want to address that some of these points do merge together. So the procedural defect, as we said, they are not entitled to say that the minister is the one who made the decision. However, in any event, we're saying that there is full satisfaction of Section 14 of the BTB Act. Why? Because even if there was any defect, procedural defect, which we are not conceding, but we're just taking that position in the alternative, then this court has found in Warrington that it is not any defect that would lead to the invalidity of the contract. And that is why we raise the Warrington point, because we raised it in the High Court and we also raised it in the Court of Appeal. The High Court did deal with some of it in its judgment. However, the Court of Appeal failed to deal with that position, which we believe would also support us succeeding in this case. We do not dispute the finding of the Court of Appeal, the ultimate finding, which was the dismissal of the BTB's appeal. However, we're saying that on these alternative points, on these alternative grounds, we would still be entitled to succeed.
Could we stop for a moment at this point? Because we're talking about an alleged defect in the decision taken to enter into this contract. It seems to me that, at least on one reading, the allegation of the defect was that the decision of the board to employ Mrs. Michael was not minuted, it was not in writing, and there was no evidence that the board had in fact taken that decision. So that is what was referred to as an irregularity or a defect. Is that applicable or is that relevant in the Warrington case when there was no requirement for the consent of the minister, the prime minister, to be in writing?
Well, it was applicable in the Warrington case that there was no requirement for it to be in writing, but we say that
Yes.
that is similar to our case here because there is no requirement in section 14 for the approval to be in writing, either
But
of the minister
how else
or
would
of the board.
how else would the approval of the board be evidenced except by the minutes of the board?
Well, we say that the approval of the board can be evidenced by the conduct. And that is why what we want the court to focus on, because this employment arrangement wasn't happening in a void. Ms. Michael was providing services for over a year. She had received an employment contract signed by
Well,
persons
that may
that
well
had
go,
authority.
counsel. Hello, counsel. That may well go to the issue of acquiescence, for example. But we leave with a prior situation of evidence of the approval of the board of the contract. And I'm just wondering whether it's not reasonable to say that that evidence will be provided by the minutes of the board, which necessarily would be in writing.
Your Honor,
Would you agree?
Mr. President, we respectfully disagree because when we looked at section 14 of the Act, which is the governing provision, it says that the board shall, with the approval of the minister, appoint, subject to
Yeah.
subsection 1 of this section, the board may appoint and employ.
Miss Manuel, yeah, yeah, but do we not have to read the act in its totality?
Yes.
So you extract section 14 and you say section 14 does not say it has to be in writing or minuted. All right, section 14 clearly does not say that. But are we not to make sense of the entire act and understand what the act prescribed as a governance structure and required normative practices for the running of this? I think in Belize it's a statutory board. In different regions it's called different things, but is it a statutory board in Belize? Is that what you call it?
Yes.
Yeah, right. Okay. So that you look at the act is creating a framework for governance, and it has checks and balances because it is a public authority accountable to the public. So my question to you is, are we to be limited in looking at section 14 only in understanding what the governance requirements are, or are we to look at the entire act and any other subsidiary regulations or legislation that be supported? Conceptually, what should we be doing?
Yes, Your Honor. Well, we say that even if looking at the entire act, the court did find, and the court will see that the BTB did know when it would be requiring things to be in writing. So the BTB Act did stipulate for matters to be stipulated in writing, and the court looked at that provision in the current Bevans case. It explicitly set out what were the provisions that required to be in writing. So it said that the BTB knew when things were required to be in writing and when it would not. So here, if section 14 was to put the requirement that it must be minuted, it would have included it, but it did not do so. So we're saying that just as in Warrington, the approval could be verbal. So that is the position, that the approval could be verbal.
Okay, very well. I think we understand you. We get you on that point. I don't want to hurry along, but there are a few minutes left. So did you want to go on to the next point of the cross appeal?
Yes, well, I do want to make the point that the approval of the board could also be by way of conduct. And that conduct could be expressed by way of the termination letter stating that we are terminating you pursuant to the contract. So it shows that they have approved the contract. The conduct of the BTB is that they were paying these salaries to Ms. Michael. So all of that is the conduct showing that the BTB has approved the contract.
Ms. Munoz, is there evidence in this case about the appointment of, in the past practice of the board about minuting appointments of heads of department, HOD marketing, predecessors of Ms. Michael? Is there any evidence about that in the past, how it was done?
In this case, there was no evidence put forward that this was the approach taken by the board. So it is not something in the past. There is no evidence that this was required or that it must be minuted. So that is why we're saying that verbal and the conduct of the BTB shows that they had approved the contract. So that would lead into our Warrington point, because if they have been approving the contract, they have been operating under the contract, then the contract has been approved, and that leads into satisfying section 14.1, even if section 14.2, I'm sorry, even if retrospectively. So we say that Warrington gives the court this authority, because even if there was a defect at the beginning, the subsequent conduct of the BTB.
Miss Munez, I don't want to be rude, but I think I will say to you once again that we have taken the point. If you
Much
wish to
obliged,
move
Your Honor.
on to another point in the cross appeal, you're welcome to do so, but you have 4 minutes to do that.
Much obliged, Your Honors. Your Honors, I do want to elaborate on the actual authority point, because we're saying that under section 8.3 of the Act, which does not require for a corporate seal to be placed on the documents, the vice chairman and chairman acted with actual authority to be able to signify the contract. So we're saying that section 8.3 grants that authority, and they were operating under that section. So they are not out with the Act.
So the evidence for the actual authority you're proposing is the affixing of the seal of the board?
No, Your Honors. We're
What?
saying that under section 8.3, that
Right.
doesn't require the affixing of the seal. So it was held that there was no requirement for the affixing of the seal on an employment contract. So what we are saying is that that section authorizes the chairman and vice chairman to be able to signify the employment contract. So that would
See.
mean that there is no procedural irregularity.
Very well.
Unless I may be of further assistance to the court, those are the points we have on the cross appeal.
Oh, thank you very much, Ms. Wanez. I think we are now ready and available to hear Mr. Courtney in his response, if he wishes to give one.
Most grateful, Mr. President. I start by commenting as I continue. I'm still at a loss to understand why it was necessary to do this and the impact of the submissions on the Bevans appeal. In any event, Your Honors, I will respond only to the point, the quasi-preliminary point made by my learned friend, Mr. Barrow, Senior Counsel. At page 211 of the record, beginning at page 211 of the record, is the counterclaim. The counterclaim challenges the validity of the contract on the basis of section 14 and section 7 of the Act. At page 214 of the record is the reply to the amended defense and the defense to the counterclaim. Nowhere in the reply to the counterclaim is a point taken that it is not open to the BTB to present an alternative case challenging the legality of the contract. They do not raise that point before the High Court in their pleadings. In the Court of Appeal, Your Honors, the Court of Appeal, notice of appeal, the notice of appeal in the Court of Appeal appears at page 1809 of the record. I will read just one ground, which is ground 3.8 at page 1813 of the record, which says, the learned trial judge erred in law and misdirected herself in failing to determine that the written employment contract was ultra vires the legal powers and capacity of the BTB as a statutory body because a written employment contract was not approved by the minister and or by the board as required by section 14.2 of the BTB Act. I pause simply to make 2 points. One, it was in fact raised in the notice of appeal, the validity of the contract pursuant to section 14.2. And secondly, to make the point that nowhere in ground 3.8 does it say because it was not in writing as appears in the chapeau in the judgment of the Court of Appeal. Your Honors, my learned friend took you to the judgment of the Court of Appeal, and quite rightly, at paragraph 8, it starts out further in the alternative. So it's an alternative point that was taken in the reply, in the counterclaim. The Court of Appeal acknowledged that it was an alternative. She sets it out in paragraph 9. Before this court, the notice of appeal appears on page 2 of the record, and it says, the Court of Appeal erred in law and misdirected itself in failing to find that on a true construction of sections 8.3, 12, and 14 of the BTB Act in particular, that the authority and capacity of the BTB to enter into the written employment contract are coextensive, so that the board was not only without actual authority, but also without the legal capacity to enter into the written employment contract. There is an unbroken thread from the High Court to the Court of Appeal to this court of the BTB raising the validity of the contract, not only on the ground of section 7.13. Your Honors, it is my respectful submission, and could I just make the point that my learned friend at each level have made full submissions in answer to this.
Yes. You know, as I follow him, Mr. Courtney, Mr. Barrow is saying that at the time of the pleading, that's a little late, because what had happened before, i.e. at the time of the termination of the contract, is that the board had relied on the contract to terminate the contract. And therefore, at that point in time, the board must have been acting pursuant to what it regarded as a valid contract. So later on, when there is a counterclaim, that's too late, because the board has already approbated the contract. How do you respond to that?
In the following way, Your Honor. First, as a matter of pleading, if that is the position, you must take that point in your pleading, but more substantively, it is always open to any party to raise a pure point of law that goes to the validity of a contract. You cannot, Your Honor, have a situation where a statute provides for a public body to enter into contracts, to bind that statutory body, to commit public funds, and when it is discovered that there is a non-compliance, that the law precludes that party, that statutory public body, from raising that illegality. The authorities are before the court in the Bevans matter on that point.
Mr. Courtney, non-compliance, you say, the case for the appellant for non-compliance rests, does it not, on the absence of evidence that the board considered the appointment during its meetings? Isn't that the case? That the minutes say nothing about that? Or is it non-compliance in fact, and which is backed by evidence?
Your Honor, I want to be very careful in what I say. The evidence adduced and cross-examination at trial was on the basis that the BTB was unable to pay Mrs. Michael. I have not, and I will not argue that on the evidence before the court, that basis has been made out. What we are left with, therefore, is the question of whether there is a pure point of law as to whether or not this contract was entered into in compliance with the statute.
But the
In
point
answer-
of law must be based on fact, doesn't it?
Right. In answer to Your Honor's question, it is our respectful submission that what the evidence reveals, and I think this is the point you are driving at, what the lack of evidence reveals is that the board took a decision to appoint Mrs. Michael. Now, Your Honor, it is going to be our submission that when one reads the BTB Act as a whole, the board is required to make decisions. The board is required to take those decisions by majority. The board is required under the Act to minute the decisions that it has taken. There is no evidence that that was done in this case, and we will ask the court to draw an inference that the board did not make that decision.
So the case, as I was saying, rests, as you see it, on the absence of evidence that the board took a decision to appoint.
I can put it no higher than that, Your Honor, but I will say again, being fully frank, we cannot say that she was not in fact employed.
Fair enough. Look
She
at,
worked there.
Mr. Courtney, help me.
It's on the contract itself.
Help me look at section 14. The section 14, the side note there said appointment of staff. So that deals with and if you look at that, okay, 14.1, appointment of director of tourism, we'll deal with that on the next segment of this case. But looking at 14.2, 14.2 in fact indicates the appointment of all staff of the board, both staff that are at the pay grade of $8,000 and those that are below that pay grade. So this is where the authority to appoint them rests. Is that correct?
That is correct, Your Honor.
Is it the case that the board has in its minutes has to account for all these appointments that it must make under 14.2?
Well, Your Honor, it is my primary position that it ought to be in the minutes. I would accept that there may be instances where appointments are made and they're not in the minutes per se, but there must be some record in the BTB that A, B, C, and D have been appointed, and they have been appointed by the board. The board must, that's the way the board could delegate, for example, anybody who is earning below a certain point, the director can go ahead and make those appointments, or the head of human resources, as the case may be. But there has to be, in order for there to be good governance, and what this act requires is records for a public body to be
I doubt very much that the case for the respondents, I don't think they dispute that general proposition that proper management, good governance requires proper keeping of records of what's done in an organization. I don't think they're disputing that from what I understand of their case. Their case, as I understand it, is that, well, if that wasn't done in the past and it's been the business to do things in a way that didn't account for record keeping properly, that the respondent doesn't have to pay for it this time, for the lesson to be driven home that there needs to be a culture of proper record keeping. Isn't that a way of looking at it?
Yes, but what I am saying is, one, whether you find some paper record of a decision being taken, it is obligatory under Section 14 for the board to have made the decision. The best evidence of that is the minutes. The best evidence of that is some other document that provides for it, not just a say-so of someone. But Your Honor,
We'll return to that in Bevans, but let's not just, from my perspective, I've got some questions about that in Bevans, but I'll leave you to it now. President Tam now. Thank you.
Yes. Mr. So Courtney, there's something about this that I am a little troubled by. I'm very troubled by the underlying governance issues to which you refer and to which Justice Jamadar had referred earlier. And obviously we need to have good governance in relation to our, whatever they're called in individual countries, statutory boards, etc. So that's one thing, and therefore it follows from that the requirements of the statute ought to be followed, including in relation to appointment of officers. And nobody disputes that. So you're taking the strict point of law that there was non-compliance with the statute, and therefore there are difficulties with the appointment, at least on the terms being alleged by the respondent. I understand that. What I'm troubled by, though, on the other hand, is I don't think you would deny that these contracts were within the power of the board to conclude. Certainly, Mrs. Michael, the board could, in fact, conclude, if it had done so properly, the contract. And if you were to concede that, then wouldn't you necessarily be conceding then that the relevant officers, the chairman, vice chairman, could be clothed with ostensible authority to conclude the contract? And if we get to that point, then the only issue would be, one of the only issues I think, would be whether Mrs. Michael would be regarded as an insider or outsider in order to take advantage of the ostensible authority rule. So in other words, we can remain faithful to the statutory point that you're making, the strict point of law, but does that not have to contend with the other legal avenue, which allows for the conclusion of the contract on the basis of ostensible authority?
Your Honor, all that you have said on a hypothetical basis, I would agree with. The question is, as a matter of fact, what happened? And that is why, and that is why, and that is why, very respectfully, it was our preferred way to approach this, to present the Bevans appeal, where we can get into these points and match it with the evidence. Justice Ibo Suji has quite rightly pointed out that in the case of Mr. Michael, I'm dealing with an absence of evidence, and therefore it's difficult for me to advance a positive case. That is why the length of my submissions are as lengthy as they are. My learned friend, to quote a judge, is pushing against an open door as far as I'm concerned.
Okay, so we can defer further interrogation of that point, perhaps to a later time.
That would be my preference, Mr. President.
Very well.
So, Your Honor, to summarize
Yes.
this issue, the quote-unquote preliminary point.
Mr. Courtney, before you do that, I just want to invite you in your summary to The President raised with you the requirements of the statute, the necessity of the requirements of the statute to be followed. As a matter of standard company law practice, because there's nothing new about boards having to make decisions. Yeah. What is the standard best practice? So when Section 14 says the board may appoint and employ, etc., subject to approvals, I mean, what is the standard best practice surrounding that? Do we have anything on that? And if not, can we get something on that? If you don't have anything on that, that's fine. But in other words, I know that the argument has been about what are the statutory requirements, what is the evidence, but what I think certainly I would appreciate is as a matter of law and best practice, it could be in Belize, preferably, that's even better. When you say a board must make a decision, what is normative around that?
And it must be minuted.
But anyways, I think that something of that, I don't want to keep us back, President. Yeah.
Yes, we don't want to stamp too much on your summary because we're going to take a break and then come back for the Bevans appeal. So if you want to respond to this precise point in your arguments there, then you're welcome to do that.
Mr. President, what I would say is the following. There is nothing before the court in terms of any learning, academic or otherwise, on that point. But what I will do is to take the court to the minutes that are before this court, where this court will see the standard, routine, consistent practice of the BTB as to how that board took the decisions, minuting it, resolution after resolution, showing that there was a clear and consistent practice of ensuring that the decisions of the board, minor and major, are all minuted and documented.
Mr. Courtney, on that.
That's partly what I don't want to burden us now, but you see, my very rudimentary understanding is a board decision is preceded by documents in which, for example, there may be a draft proposed resolution. The decision is often taken in terms of something put forward or so be it resolved that so and so shall be appointed. So that's what I meant when I was speaking about best practice. I'm happy you appoint us to this board, but I also would like the more normative thing, because there is, I believe, a very clear normative practice that isn't just restricted to the minute of the decision. Something happens before, as I understand this process. At least in my rudimentary experience.
Yes, I think though we may have to allow Mr. Courtney to speak to the facts and the practice in this case. I am not sure whether we're going to be able to draw on the experience in other jurisdictions. Certainly not in this hearing. Yes, my brother.
Yes, on the facts of this case and the practice, Mr. Courtney, you said you will produce records of how the BTB does things. Would the record you produce show us how BTB made previous appointments of staff, especially HODs, especially the predecessors in office of Ms. Michael?
Your Honor, what is in evidence are previous contracts, but not minutes that took a decision to appoint previous directors.
So previous contract like the one Ms. Michael had?
Previous contracts for previous directors of tourism and other persons, but
all right, thank you.
Not any minutes, as I recall, where a decision was taken by the board to appoint a particular staff.
Anything further, Mr. Courtney?
Your Honor, all I wanted to say is that in response to my learned friend, Ms. Munoz's submissions, we rest on the written replies that we made to the cross appeal.
Very well.
Obliged.
Thank you very much, Counsel. So we will adjourn for a short period of time, 15 minutes. Justice Ibo Suji, I think you're the one who suggested we take a break.
Indeed, 15 minutes.
Indeed, 15 minutes. So we will resume at 10 minutes to 1 Trinidad time, 10 minutes to 11 Belize time. Thank you very much.
Obliged.
Thank you. So we are now to hear the appeal in the Karen Bevans case, and we'll hear first from the appellant for 45 minutes. Mr. Courtney?
Much obliged, Mr. President. May it please the court. Your Honors, I just wish to confirm that you have the benefit of the speaking note, which I filed yesterday and also served on my learned friend.
I personally haven't seen them, but I gather my colleagues have, so we're good.
Obliged. Your Honors, I propose to stick very closely to the speaking note in order that I can complete within the 45 minutes. This, of course, is an appeal against the decision of the Court of Appeal, the judgment of the Court of Appeal, in which the appellant was ordered to pay to the respondent $769,869.44 as damages for wrongful dismissal. Your Honors will be aware that the appellant says that the Court of Appeal fell into error in finding that the employment contract was binding against the BTB. It will be our respectful submission that that contract was ultra vires the BTB Act, and that it could not and was not cured by acquiescence or estoppel. And finally, and in any event, that clause 7.11 is a penalty and provides for the payment of a penalty and is unenforceable. Your Honors, at paragraph 2 of my speaking note, we make 6 submissions. In order to make good those submissions, I wish to trouble the court to take you specifically to the evidence. And I want to say very frontally 2 things. The first is that it is our respectful submission that a full appreciation of what I called in our written case, the narrative, or to be more accurate, the facts of what actually happened is critical for the determination of this appeal. And secondly, with great respect to Madam Justice of Appeal Arana, it is our respectful submission that she fell into error, not so much, although we do disagree with some of her analysis of the law, but more that a failure to grapple with the actual facts of the case and to apply the law to those facts. So if I could ask the court to start with the cross-examination of Mr. Manuel Heredia, which appears at page 1078.
Mr. Courtney, forgive me, but I must come in here. Don't lose your train of thought. You said for us to go to the cross-examination of Mr. Heredia. You say that it is important to come to firm grips with what actually happened in this case. Can I take you, please, to Appeal Records 236, if you don't mind?
What page?
Page 236 of the Appeal Records. And this is part of what I believe to be the testimony of Mr. Evan Tillett. I say part of the testimony because I believe this was introduced in his evidence as his testimony in chief. This is a statement of Mr. Tillett's evidence, his written statement. Are you there?
Yes, Your Honor.
I'm looking at paragraph 6 of Mr. Tillett's statement. It says, following my appointment as chair. Are you there?
Yes, Your Honor.
Right. Following my appointment as chair of BTB's board in November 2020, one of the major issues we had to tackle was the severe financial constraints which the BTB faced as a result of the COVID-19 pandemic and the decline in tourism. since BTB was operating at a deficit, the board formed the view that it should cut its costs, the largest of which was the claimant's salary. In or about early 2021, I therefore had discussion with claimant regarding a consensual termination. Let's stop there. It doesn't say we're facing severe financial constraints. Ms. Bevans, would you agree to a lower salary and continue? Simply says financial constraints, let's agree to your consensual termination. Is that a fair understanding of what happened?
Well, Your Honor, it doesn't condescend to more particulars, but what I understand here is that the board felt that it was operating at a deficit. It needed to cut expenses. The largest expense was the respondent's salary. And so the then chairman engaged with her to see whether they could arrive at an amicable termination.
Termination, not reduction in salary to safeguard the termination.
That's my understanding.
All right. Is it the case that Ms. Bevans was in fact replaced by somebody else?
Ms. Bevans, well, Your Honor, could I just back up and say, unlike the Mr. Michael contract, there is no provision in Ms. Bevans's contract for her to be terminated on the basis that the BTB is operating under severe financial constraints. That clause is not in her contract. So
Fair enough.
no reliance was placed in terms of termination on the basis that the BTB was suffering severe financial constraint.
But she was eventually terminated, and,
yes.
and who replaced her?
I can answer you in a short while. I suspect, and I would prefer not to speculate. I believe what happened is that the then chairman became the director, but I'm not sure, Your Honor.
And the then chairman being Evan Tillett, is that correct?
I believe that may be correct, Your Honor.
So would it be the case that what happened was that Mr. Evan Tillett was an interim chairman of the board at the time Mr. Bevans' contract was terminated?
Your Honor, I hesitate. I believe that is correct, but I'm going to get it confirmed immediately.
I think you can see that actually from the records of the testimony. If you go to Appeal Record 1095 to 1096, we have all that information.
Yes.
That is the transcript of the trial.
That is correct.
Are you there?
Yes, Your Honor.
All right. So at 1095, examination in chief of Evan Tillett confirms him as director of tourism.
That is correct.
All right. And then further down, it also says that he was chairman and acting director of tourism until 2021, then removed as chairman and became the substantive director of tourism. Is that my understanding?
That is my understanding of the evidence, Your Honor.
So that's the same person who was seeking to terminate Ms. Bevans.
That is correct.
Because of constraints of financial difficulties.
That is correct.
Is that a problem? As you see it as a lawyer?
Well, Your Honor, I emphasize again two things. One, in the event Ms. Bevans was not terminated on the basis of financial condition of the BTB, that was not the basis of her termination. Her contract didn't provide for that, and that was not done. Secondly, Your Honor, my understanding is that the then chairman was an executive chairman who was being paid, Mr. Tillett, and Ms. Bevans, who was director of tourism. So that would have been two major salaries. If one of them is terminated, the expenses of the BTB would have been reduced.
So the chairman then chooses to terminate Ms. Bevans.
Yes.
Is that how I see it?
Yes, Your Honor. On a decision of the board.
On a decision of the board. And then immediately after that, after Ms. Bevans, in terms of substantive occupancy of the position, the next director of tourism becomes who? Mr. Tillett.
Yes.
I'm saying, is that a problem from perspective of conflict of interest?
Your Honor, I do not appreciate, it doesn't really come to me as a conflict of interest. It is my understanding that the BTB Act would entitle the minister and the board to appoint Mr. Tillett or anyone else to be the director of tourism once Mrs. Bevans had been terminated.
All right. Okay, let's park that. Let's put that to the side now for a minute and proceed. Is it also apart from the question of whether or not there is conflict of interest? Let's move, assuming there is none in that regard. My next question becomes this: is it possible that the big elephant in the room in this case is about making changes? Basically, it's about a new administration has come in, a new government, a new minister, a new board, a new chair, and there was a need to also have a new director.
Your Honor, there is evidence to that effect. I would say that that is one of the elephants in the room. Your Honor, there is
because
evidence.
if you looked at sections 3 to 5 of the Act, section 3, sub 2 and 3 gives the minister the power to appoint board members. And section 5.1 makes the term of board members 3 years renewable. And section 4.1 gives the minister the power to appoint the chair of the board every year, every January. So in that arrangement, we see that any government in power would have the gift of appointing the board and also the gift of appointing the chair of the board. Is that correct?
That is correct.
But that gift also does not extend to the appointment of the director of tourism.
Not directly, no.
All right. So that in the event that that's not the case, the way to do it would be to find a way to get the director to move on, to move along when there's a new government.
Yes.
All right.
But Your Honor, can we explore that just for a short while? Because the analysis, a very similar analysis is done in Warrington, and you have my submissions on Warrington. It is my respectful submission that the Belize Tourism Board vests significant power in the minister of the day, minister with responsibility for tourism. There is no doubt the legislature intended that to use our expression, the board of the Belize Tourism Board would have the image and likeness of the minister and the director of tourism, and I would say senior staff. And that I make that submission on the basis of the language of section 14. And Your Honor, there is the evidence in this case, which no one can resile from. Mr. Evan Tillett was questioned about it, and Mr. Heredia was questioned about it. that there was a practice, not law, a practice that when there is a change of administration, senior officers at the BTB would move on, either resign or be paid off, and they leave because the incoming administration would then want to appoint, for want of a better word, their team to run the BTB. In this particular case, the evidence was the cross-examination questions led to the case being put that the purpose for including the famous clause 7 was to ensure that because the election was going to be in the next year, that if the government changed, Mrs. Bevans would be protected, so to speak, for her to move on.
Do you really have that argument if, in fact, that clause also was in her 2024 contract? How do you reconcile that feature of it with a repeat of the same clause in 2019?
Your Honor, the answer to the question in my respectful submission is the provision. Well, let me back up. I will come to the submission very fully towards the end, but my position is that the sole purpose of that clause in Mrs. Bevans' contract is punitive. It is for the purpose of ensuring that the board cannot terminate her. She can terminate her contract, and if you wish to terminate me, you have to pay me the entire amount. And so whether you put it in the context of an election and a change of government, my submission is the same. The purpose of that clause is solely for the benefit of Mrs. Bevans and contrary to the interests of the BTB.
Now, let me return you to you were beginning to take us to the testimony of Mr. Heredia.
Yes, and I'm wondering whether we may have to restart the clock because we don't want to put Mr. Courtney to a huge disadvantage. Yes, please proceed, Mr. Courtney.
Can I very quickly, Your Honor, and I know that this is unusual, but it is central to the case for the appellant. Mr. Heredia's evidence starts at page 1078. You will recall that he was the Minister of Tourism for the relevant period. Your Honors, I don't know if I'm going to lose contact. We just suffered a blackout where I am.
You're not on the board, I hope.
The power has come back.
You're back. Okay.
We can see you. It did accentuate your features, though.
Yes, it did.
I asked the court, of course, to read all the evidence, but can I ask the court to start at page 1083? And I want to take this as quickly as I can, but it is central to my submissions. The very last line on page 1083. Who negotiate terms of renewals? And this is the minister speaking. I cannot say. Wasn't it you? No, it wasn't necessary. Did you cause any record to be made of the approval? No, does not have to be in writing. Shouldn't there be a record at the BTB of approval? The act doesn't say that. We skip down a few lines to line 16, which, and I'm paraphrasing because that is clearly a typo.
Yes, Counsel, could you just hold a moment?
Sorry.
I think our Deputy Registrar wishes to intervene.
Yes,
Mr. Barr is
please.
frozen?
Frozen or disappeared. Maybe at the same time when Mr. Courtney's features were expanded, when they had to black out.
Accentuated, I think is what was said.
Accentuated, yes, thank you.
So can we pause for a moment just to make sure that Mr. Barr is
Thank you
with
so
us?
much.
Yes, thank you, ma'am.
so much.
Yes.
Yes,
Is contact being made with him? Thank you much. Mr. Courtney?
Obliged, Mr. President. I wasn't sure how far I had reached when we dropped off, but if I can just go back, I was on page 1084 of the record, reading from the cross-examination of Minister Heredia, and I had gone down to line 16. Which body within the BTB engages the services of Karen Bevans? He answers, I'm the one to approve it, then direct the chairman to execute what was approved. Must the board consider and approve engagement of Karen Bevans as Director of Tourism? Once I looked at both contracts, I believe it was the best interest to engage for a second contract, and I instruct the chair to execute. You have the power under the BTB Act? Yes. Point to the section in the Act. Section 14. Is your understanding that the minister appoints and instructs to execute the appointment? Yes. Matter need not be considered by the entire board. After approval given to chair and board decide how to handle it. Board and no individual discretion or exercise. Once the minister approves, the board follows the instructions of the minister. Did you instruct the board to renew? I instructed the chairman. Are you able to say if the chairman presented to the board? My understanding he did. I heard from members of the board. They were pleased. He accepted the second contract. Record in the minutes? No. Inform afterwards. The board executed the contract. How does board execute? I cannot tell you. Then there's a question at line 10. When was the contract executed? There's not much on that. If I can now ask the court to look at page 1087, the cross-examination of the chairman, Mr. Gomez. Were you instructed late March to attend to the contract renewal for Bevans? I can't remember the exact date. You received instructions from Manuel Heredia? Yes. What did you do? I liaised with the director to review the draft due diligence. Line 5, who decided the terms? The minister. Did the minister indicated how? Verbally by phone, agreed to draft renewal contract and I should sign. Who presented the draft for signature? I don't recall. How do you know that the draft was the same as the minister? I assume the minister approved. The minister said remuneration was the same, but adjustment to phone and housing allowance. Of course, the remuneration changed. Clause 7.1, the minister, nothing said about that. Did you put the draft before the board? No, did not have to. As a matter of board approval for consideration, didn't have to. Issue of renewal was discussed many times. The old contract was about to be completed. Is there any discussion in the minutes? No. Did the board pass a resolution to engage Bevans as Director of Tourism? Not that I recall. Your understanding of approval of the board is not required? Yes. Understanding once the minister instructed, you were authorized to sign the contract? Yes. There's a yearly review of performance, everything done in accordance. Acted purely on the instructions of the minister? Yes. Signed contract before the board for approval? No. Did you inform the board the contract was signed? Yes. Did the board do anything? Accepted unanimously. Was this recorded in the minutes? No. We can now go to page 1091. Line 5. Is there a formal process for the engagement of the Director of Tourism? The yearly fiscal review plus performance, previous year plus 1 plus 3-year plan. That is when we acknowledge the work of the Director of Tourism. Is there a formal process for hiring of the Director of Tourism? The board does not hire the Director of Tourism. Who? The minister. The minister hired Karen Bevans? Yes. Was the post advertised? I don't know. Any applicants? I don't know. Who negotiated the terms and conditions of the Bevans employment? The minister. Did the board have input as to the terms and conditions? Not to my knowledge. Did the board pass a resolution authorizing a seal on Karen Bevans' contract? Don't recall. Your Honors, Mr. President, that, in my respectful submission, is for purposes of the appellant's case, the critical pieces of viva voce evidence which was given at trial. In our written speaking note at paragraph 2, we make 6 submissions. And those 6 submissions, in our respectful submission, are borne out by the evidence which I just reviewed. The submissions are the following. The decision to reappoint the respondent as director was purportedly made solely by the minister, and it is our submission he had no power to do so. The board never decided to reappoint the director as required by Section 14(1) of the Act. The minister and the chairperson were of the opinion that the board's approval of the respondent's reappointment was not required. After the purported contract was sealed with the BTB seal and signed by the chairperson and deputy chairperson, acting on the sole directive of the minister, the chairperson informed the board of the reappointment and the board merely accepted it. The board did not pass a resolution authorizing the sealing of the purported contract as required by Section 8 of the BTB Act. The purported reappointment of the director by the minister and the sealing and signing of a purported contract by the chairperson and the deputy chairperson were ultra vires the BTB Act and does not bind the BTB, and it was not cured by acquiescence of the BTB. Your Honors, if I stand back and analyze the evidence, clearly what happened here was a minister who decided that under the Act, he had the power to make the appointment of the director. The chairman was also of that opinion. The board clearly was of that opinion. Why do I say so? There is evidence in the minutes of, I believe, the 25th of April, 2019, in which the board, it is minuted that the chairman and the minister are dealing with the contract. The decision is taken by the minister to renew. He instructs the chairman to get it done. The chairman gets it done, signs and seals along with the deputy chairperson. After the fact, he reports it to the board. Everyone applauds. That is because they were all of the same political party. They were all appointed by the minister. What then happened was that there was a change of government, and the new board, as is customary, reviews what the previous board did. There is
Sorry,
no...
when you say, Mr. Courtney, that they were all of one accord, that word all, does that include the respondent here?
Well, Your Honor, I looked at the Act, and I believe the Act says that the board shall appoint 5 members, a minimum of 5, not more than 8. And when I look at the minutes, they consistently had 9 persons. I'm not sure that the respondent was appointed or whether she was ex officio attending the meetings. In any event, I believe the question that you're asking me is more specifically as to whether or not she was a political appointee, if I understand your question.
Well, I'm still on the issue of the ostensible authority, because all of what you have said, let us take that as being valid. But if the making of this contract was within the power of the board, and that contract is normally signed off on by the chairman and or the vice chair, then why is it that in this case that could not be done, and the contracting party, an outsider, is then bound to the contract concluded by the representatives of the board? I do take your point, and we don't want to rehash that there are governance issues that are important. But in relation to the law, surely the board, if this is within the power of the board to contract, can, be bound by the exercise of ostensible authority by the relevant officers of the board.
Mr. President, with greatest of respect, and that is why I took the pains of going through the evidence. And as I said to you earlier, on a hypothetical basis, yes, ostensible authority will have bound the BTB. Hypothetically, what we have here, as a matter of fact, is a chairman who supposedly is clothed with ostensible authority, saying on evidence, the board has no power to make the appointment. It is the law that if an agent is clothed with ostensible authority, it must come from the person who has actual authority. What we have in this case is, as a matter of fact, the chairman saying the board did not have the authority. It was the minister who had the authority. So the quote unquote authority to execute in this case, as a matter of fact, came from the minister. And we know Section 14 does not vest the minister with that power. And so, Your Honor,
Are we sure about that, Mr. Courtney?
well, Your Honor, can I read the
Let me
section?
tell you, yes, we know I've read Section 14.1 repeatedly, and I hear your submission, but is there a missing piece there? You say in your written your note of skeleton of argument that the board saw itself and everybody saw the board as merely a rubber stamp or something less than that.
Less than.
Now, do we read, if you look at 14.1, is that really outside of the interpretation of 14.1? The board shall, with the approval of the minister, appoint. Yes, we know with the approval of the minister, but what 14.1 doesn't tell us is who actually makes the selection. Selection is not always the same thing as appointment, you know.
Well, Your Honor, we are not questioning the selection.
So that
We
the
are
minister
just-
can select, right?
Oh, yes, the minister can say, I have chosen Ms. Bevans. I would like her to be appointed. In fact, I have negotiated some terms with her. Here are the terms, and I would like her to be appointed.
And then the board shall, according to 14.1, if that's the case, the board shall make the appointment
Your Honor,
in those circumstances.
That is,
I'm not saying that's the way it must be read, but I am saying, do we have that ambiguity in which the way you see it as a matter of proper conduct, giving substance to the board to appoint? Yes, they can select, give to the minister approves, and then they appoint. Or alternatively, the minister can select and the board appoints. As an alternative way of reading it, it creates ambiguity, but it's not ambiguity that those who drafted Section 14.1 created.
with respect, Your Honor, my submission is no.
Yeah.
It is not on my respectful submission ambiguous. It is my respectful submission that the board and the board alone has the power, and the board shall appoint the executive officer. The minister may propose a person. The minister may propose terms. And if the board has a difficulty with it, it is my respectful submission that the board is not obliged to follow the directive of the minister.
But
If
it's
that
up
were
to
the
the
ca-
board.
If that were the case, the
Yes.
section would read, the minister shall appoint.
But appoint can mean simply conferment of a formal recognition, formal investiture of an office upon somebody. Somebody else can make the selection and then another person required to appoint it. In that sense, formality.
Your Honor, in my respectful submission, the board is not a rubber stamp. Section 14.1 does not purport to make the board a rubber stamp.
The board is appointed by the minister,
Yes,
and the board appoints the chair. Sorry, the minister appoints the chair of the board.
yes.
Could the board then not be allowed to say, well, this is the minister who appoints us,
Yes,
who appoints the chair? They might as well be the one who appoints the director or the executive officer
Your
of
Honor, it is
the
my
board.
respectful submission that in those circumstances, those directors will be acting in dereliction of duty. Their
Yes.
primary duty is to the to the Belize Tourism Board, and they must carry out their duties in their discretion.
Mr. Courtney, there was a recent decision in Trinidad and Tobago dealing with statutory boards and the obligation of the directors, the board of directors. Have you had a chance to look at that? In which they held along lines similar, I believe, to what you're saying, and actually held directors responsible for not discharging their duties. I'm just asking, have you had a chance to look at that?
I have
Decision.
not read the decision, Justice Tamara. I have
All right.
read about it in the newspaper.
So maybe you should find it and have a look. Because I don't know it.
Maybe we should all be familiar
Well,
with
but
it.
of course,
Yes.
of course.
I-
I just
but
don't, I don't want to look at
wanted-
it and not give him the chance to,
Yes,
you know,
of
to at
course.
least raise it for his attention. Yeah.
Yes, indeed. I wanted, though, Mr. Courtney, to go back. I think we understand exactly what you're saying about the board not being a rubber stamp. But in terms of what constitutes ostensible authority, from whose point of view is that to be looked at? Is that from the board's point of view and all the rules and regulations governing the board and the discretion the board has, etc.? Or is it to be looked at from the point of view of the person contracting with the board? Which is why I would very much like your submissions in relation to this question of insider outsider. Isn't it from the point of view of the person, the outside person, contracting with the board, that we decide whether it's reasonable for that person to believe that the person with whom they are contracting, the persons were clothed with ostensible authority? Am I wrong in that?
Your Honor, I would like to take the court to the genesis of the rule in Turquoise's case. Could I invite the court to turn up that case at page 2798 of the record?
Okay.
And Mr. President, I crave your guidance to tell me how much time I have since we had these interruptions. I'm at a loss. as to how
Yes,
much-
I would say 20, 25 minutes. Yes.
Wow, okay. Page 2798 of the record. And I would invite the court's attention to 2801. Are we there, President?
Please, yes.
Are you able to pull it up? I'm finding difficulty
I'm sorry.
getting to it
Yes.
quickly from the.
I mean, one advantage of technology is, of course, you could just display it for us, Mr. Courtney, if you know how to use the technology.
You're embarrassing me, Mr. President.
I didn't mean to, sorry. Well, maybe there's some younger counsel in your office who might be able to assist us.
Perhaps I can just read it, Mr. President.
Very well, sir. Yes.
Page 2801, the last paragraph. In the very middle, well, let me read it. He said, if that be so, the question does not arise. But whether it be so or not, we need not decide. For it seems to us that the plea, whether we consider it as a confession, an avoidance, or a special non-est factum, does not raise any objection to this advance as against the company. Then this. We may now take for granted that the dealings with these companies are not like dealings with other partnerships, and that the parties dealing with them are bound to read the statute, and the deed of settlement, but they are not bound to do more. The party here, on reading the deed of settlement, would find not a prohibition from borrowing, but a permission to do so on certain conditions. Finding that the authority might be made complete by resolution, he will have a right to infer the fact of a resolution authorizing that which, on the face of the document, appear to be legitimately done. So, the genesis of the rule, Your Honors, starts with the first premise, that there has to be an internal document. The third party, the stranger, the outsider, is bound to read the statute and is bound to read the constituent documents. The statute in this case is the only document that is relevant. It is not an internal document. It has never been an internal document. I go further. The contract of Mrs. Bevans specifically binds her to saying that she will conduct her business and conduct the business of the BTB in accordance with the Act. I say rhetorically and forensically, if the chief executive officer, if the chairman of the board of a corporation is an outsider, there can never be an insider. The chief executive officer of the BTB is the quintessential insider. Even if she were an outsider, she is bound to read the statute. And your honors, I repeat the evidence in this case because it is important. Let us say Mrs. Bevans had read the statute and had read section 14.1. The chairman comes to her. She has negotiated with the minister. They have settled the terms. The chairman comes to her and says, here is the contract. She's put on inquiry because she has read the act and said to the chairman, Chairman, has the board approved? The chairman, based on his viva voce evidence, would say to her, do not worry about that. Under the law, it is the minister and the minister alone, and he has approved. The point I make, Mr. President, your honors, the facts of this case lead to one conclusion. The appointment was made by the minister. He instructed the chairman to conclude the contract. The chairman says he did so on the instruction of the minister. The board was not at all consulted on the terms. I pose another question to make good my point. The chairman proudly tells us that after signing the contract and sealing it solemnly, he took it to the board and everyone applauded. What if a director said, what are the terms? Oh, well, the minister says increase the salary by $53,000. The minister said increase the phone allowance by 50%. Increase the housing allowance. And that board member says, well, I don't agree. Another board member says, what is the term? 5 years. And they say, wait, but there's an election next year or whatever. My question is, could the board of directors at that stage say to the chairman, we do not resolve to approve this contract? On the argument of the Court of Appeal and my learned friend, on the basis of ostensible authority supposedly held by the chairman, who did not get it from the board can do nothing because the contract would have been concluded. It is my respectful submission. That would be to run a horse and carriage through section 14.1. It would put an end to the whole question of ultra vires. It would put an end to the inquiry. Who has the power to appoint and was that power exercised? It is our respectful submission, Your Honor, without a decision of the board to reappoint her with the approval of the minister, accepting the terms that the minister made, the decision is ultra vires by the minister and the contract is void and does not bind the BTB. Your Honors.
Would you agree that there might be a distinction between the two respondents in that one was, as I gather, the CEO, the Director of Tourism, the Secretary to the Board, and therefore necessarily you are saying an insider, whereas the other did not hold those positions? Or are you saying that ostensible authority does not apply in relation to contracts with public sector related companies?
Your Honor, first of all, I'm not saying that. I'm
Okay.
saying ostensible authority can apply in the case of public sector contracts.
But
Your Honor,
sorry, the person concerned must first of all read the statute. And
That
that
is
would put the
correct.
person on inquiries.
that is correct.
I see. Okay.
Your Honor, having said that, I crave the court's indulgence and I want to focus on the Bevans appeal. Mrs. Michael's factual situation is different.
Okay.
I'm asking the court to apply the legal submission I make. One, that she was put on inquiry. Whether she's an insider or outsider, Your Honor, is a matter for the court to determine. What I am saying is whether she's an insider or outsider, she was obliged to read the statute. The focus of the BTB is on the Bevans appeal. Could I just make the point at paragraph 6 of my speaking note, Your Honor, because Your Honor, the President has asked more than once the question of ostensible authority. I have cited East Asia and the Law Debenture Trust, and I have cited the paragraphs which we rely on to say that ostensible authority can only arise from a person who has actual authority, who by representation, oral, writing, or by conduct gives to that agent authority which the third party or the member of the public believes, based on conduct or representation, that the person is authorized. It is a relationship between the principal and the third party, who by his conduct or what he has said to that party, you can rely on my agent. In this case, the facts are that the principal is, in my respectful submission, the board. That is the entity vested with the power to appoint. And so, Mr. President, to answer your earlier question, whether ostensible authority could arise in public sector contracts, it's quite easy for the board to say, or a practice could have developed, where a person, head of human resources, for example, for years on end, signs contracts or orders goods and services, etc., and it carries on and they honor the contracts. And so they have ostensible authority. So I'm not saying it doesn't happen. What I am saying in this case is that the minister did not have actual authority to authorize the chairman to execute, and therefore the argument of ostensible authority does not succeed. On the
Does
question,
it not succeed? Does it not succeed? Ostensible authority still, and who's an insider and outsider? It all depends on the context and also the concept of reasonableness of things will need to be taken into account. Now, in 2014, at the time of the initial appointment of Ms. Bevans, was anything done differently than relative to the power of the minister to be it hire, appoint, select? Wasn't it the same procedure? She negotiated, from what I see from the evidence, she was at the telecommunications company, about to finish her tenure there. Vacancy occurred at the BTB. The minister contacted her, more or less headhunted her, and interviewed her with two, I believe, people not indicated to be members of the board, and then told her you will be offered a contract, and she got it. More or less, wasn't that what happened in 2014? So the minister exercised that authority as far as she could see then. So was it, assuming that's the case, was it unreasonable of her to say, well, the minister who appointed me in 2014 could also reappoint me in 2019.
Your Honor, I have to confess that you have given far more detailed evidence, and from what I have read.
That's from the
she
record,
was-
actually.
No, well, sorry. All I'm saying is, I'm not saying it's wrong. I'm just saying, from my recollection of the evidence, she was headhunted, she was interviewed, it was a competitive process, and she was selected and appointed. Where I differ slightly from Your Honor is, I don't recall the evidence saying that the board did not appoint her or that the minister appointed her. I don't recall the evidence saying specifically who actually appointed her in 2014. Yes, she was headhunted. Yes, she was competitively interviewed, etc. That's not denied. I don't recall, and I will check it when my learned friend is making his submissions, but I don't recall specifically evidence that it was the minister who appointed her. What the evidence...
Mr. Courtney, can I interrupt you a little bit? You say staying with the ostensible authority point and the insider-outsider. If this person is the CEO, secretary to the board, we only have a statute here, so they have to read the act. They read the act. Why is it not that they would assume that what the acts required to be done was done? Why could that not have been a reasonable assumption in relation to the 2018 contract? I think it is, but this one is current. Why on the evidence? Because the requirement is that you read the act. The act will say this is what has to be done. What in the evidence suggests that she should have been put on inquiry that something untoward was in fact done?
Your Honor, the only answer to that is the scenario which I painted. If Mrs. Bevans had read the act, if Mrs. Bevans was familiar with Section 14, it is my respectful submission that
she should have been put on notice that the board is the only entity that could have appointed her.
Right. And the facts are from her that she went to the minister and said to the minister, let's renegotiate. She renegotiated with the minister, and the minister said, I will tell the chairman. The chairman...
I know, I understand that, but
I am saying, Your Honor, being put on, sorry to interrupt, but being put on inquiry means not that you notice, but you ask.
But being put on inquiry means there needs to be clarity about what the provision says. Section 14(1) has to be unequivocal in what it says, so there's no room for ambiguity. Doesn't that mean that? You
have my submissions on that, Your Honor. Yes. In my respectful submission, 14(1) is unambiguous.
Well, look at page 192 of the appeal record, my previous question. I don't know whether you need, President, I don't know whether we have time to do that, but page 190, for instance, is the beginning of the witness statement of Ms. Bevans, and 192, you see paragraph 7 and 8 of her statements, more or less what I paraphrased, but again, we don't need to dwell on that, just so you know where I was coming from.
No, Your Honor, I agree. All I said is that I don't recall any evidence as to who made the appointment in 2014. But, Your Honor, sorry, just to respond back to Justice Jamadar, what I'm saying is, once you are put on inquiry means that you must ask, you must inquire. That is what it means. It is not just to look at 14.2 and say, well, the board must approve. And if the chairman comes to me, I just simply go ahead and say, fine, no problem. In the factual context, where she had only had discussions with the minister. That's the highest I can put it, Your Honor. Your Honor, I am running out of time, and there are a couple of points that I need to address before we close. Your Honor, paragraph 8 and 9 of my speaking note We cite the cases which say that if the contract is ultra vires, that acquiescence and estoppel cannot cure the nullity.
Sorry, what paragraph is those? Paragraph 8, you said?
8 and 9 of the speaking note. And then we cite the cases at footnote 7.
I see. The Pacific Coast and
Pacific Coast,
Real
Real
UDC.
UDC, and Abiquick Marama.
Yes.
And Your Honor, the essential point there is if it is a nullity, it is not open to a party to say, but 1 year has passed, you have paid me my salary, and therefore you have acquiesced in the illegality or the nullity, and therefore you're stopped from residing from it. And the reason for that, Your Honors, as the cases say, is it would then remove from public authorities and public bodies their duty to act according to law. The court would in effect be blessing a nullity. It would not be holding directors.
Mr. Courtney, I get that. That's the principle of legality in operation. So let's suppose that applies in this case. It's so that the contract is void. Here you have a person, they've been employed, the contract is void. Is it then that outside of the contract, per se, they have no recourse to any relief?
That is not the case of the BTB on this appeal, Your Honor. And that's a point that I think I made at the very beginning of the speaking note.
Yeah.
There is no doubt we cannot say that.
That is your $200,000 paragraph, right?
That's my point.
Yeah.
That is
And the substantive argument you just made about the nullity and the inability of acquiescence to cure that, I assume that's your answer to Mr. Barrow's preliminary point as well.
Yeah, indeed.
Yes, okay.
Is there a difference between nullity and voidability? What if it was not a nullity, but merely voidable?
Your Honor,
Acquiescence would apply, doesn't it?
yes, if it is, and we do not accept this, if it is a mere irregularity or some, as you say, voidable, then it would seem on principle that it can be acquiesced. I think there's a quote from Lord Denning that if it's a mere infraction, a mere irregularity, it's a trivial thing, it can be, but then that's not a nullity. That is not ultra vires.
So that's not your argument. That's a different argument. Yes.
Our argument is that it's ultra vires and therefore cannot be cured.
Yes.
You have my submissions on the penalty issue, and we emphasize, just to close on the point raised just a short while ago, the BTB did not act unconscionably or outrageously in the treatment of Mrs. Bevans. She was paid nearly $250,000 when she was terminated. She was given 1 year salary and benefits on termination. She is obliged, because she sued for wrongful termination, to mitigate her damages. At trial, which was shortly a year, just I believe about 14 months after her termination, she testified that she had already been employed in a new job, earning $90,000 US, $95,000 US plus benefits. The long and short of it, Your Honors, is if clause 7.1.1 is enforced, we submit it would be a tremendous unwarranted windfall to Mrs. Bevans. And Your Honors, final point on this, because it seeps all the way through the evidence and the judgments. The notion that clause 7.1.1 was inserted in order to give Ms. Bevans security does not withstand scrutiny. Clause 7 provided a fixed-term contract with the right of Mrs. Bevans to terminate it on 3 months' notice. The BTB did not have the right to terminate her, other than for cause. Therefore, she was absolutely secure for the term of the contract. She could have chosen to leave. The BTB could not have separated her. What then was the purpose of 7.1.1 other than to punish the BTB if it terminated her? The BTB took the position that the contract was void, the employment existed, that having regard to her status, having regard to her professional reputation, 1 year compensation was sufficient time and sufficient compensation in lieu of notice. It turns out that she was employed.
Mr. Courtney, wasn't provision similar to clause 7.1.1 inserted in other contracts of employment concluded by the BTB? Was it unique to Ms. Bevans' contract?
No, it was not unique to hers.
So this penalty or punitive provision was inserted in other contracts?
It was in other contracts, Your Honor, and my understanding from the evidence is that in some cases it was honored. Other persons had been separated when there was a change in administration, and the incoming administration says, okay, I see the clause, here is your check. That does no violence to the legal argument that we offer today.
Very well.
Your Honors, we ask that the appeal be allowed with costs here and below. Unless I can be of any further assistance, those are my submissions.
Thank you very much, Mr. Courtney. Mr. Barrow?
So Barrow, you're muted.
I'm sorry.
Yes.
Forgive me. I wonder if I could begin by looking at the BTB Act, because I hope I'm not sounding as though I'm being opportunistic, but I certainly was very much taken with the interrogation of the relevant sections that His Honor Mr. Ibo Osuji undertook. And in fact, I had said something similar at the first instance hearing of this matter. Your Honor, paragraph 14, section 14 of the BTB Act. The board shall, with the approval of the minister, appoint a chief executive officer to be called the director of tourism. And could I just make clear, I'm sorry, Mrs. Bevans is not the secretary to the board, was not the secretary to the board. She was invited on occasion to attend meetings, but she was not the secretary. The secretary was a Miss Tanya Woody. So that in terms of the insider-outsider argument, that should be made very clear. Forgive me.
Yes, okay, we have that. So she was the director of tourism?
Yes, yes.
And was she also the chief executive officer?
I don't know if she was called chief executive officer, but in effect, I think she was. But
Okay.
she certainly was not a member of the
This
board, and she was not secretary to the board.
Yes. Point taken. You look
if
at
I-
that. Thank you. Please.
If I could come back to 14, the board shall appoint a chief executive officer to be called the director of tourism and a secretary to the board at such remuneration and on such terms and conditions as the minister may approve. Subject to subsection 1 of this section, the board may appoint and employ at such remuneration and on such terms and conditions as it thinks fit such other officers, agents, and servants as it deems necessary for the proper carrying into effect of this act, provided that no salary in excess of the rate of $8,000 per annum shall be assigned. No appointment shall be made to any post to which a salary in excess of the rate of $8,000 is assigned. Your Honor, it's the point that I think, Your Honor, Mr. Justice Ibo Osuji was making. There is no requirement in the section for the appointment of the chief executive officer with the approval of the minister to be done by way of a formal resolution, a formal board decision. In the course of the Mr. Michael matter, when your honors come to look at the evidence, you will see that Mrs. Bevans, who gave evidence in the Michael matter, was making the point that when Mrs. Michael was appointed, there was no question of any resolution. There was no question of any meeting of the board. And Mr. Justice Ibo Osuji's point, that makes all the sense in the world, Your Honors, that there should not be such a requirement, because you're talking about officers at the level perhaps of a messenger. $8,000 per annum. It cannot be that the legislature intended that the board would be detained on every occasion that arose for the appointment of somebody as, I hate to use the term low, somebody as junior, as a messenger, as an officer, as an office assistant, to hold a meeting and to pass a resolution.
Mr. Barrow, in the
You
case
can't
of
read.
Mr. Barrow, in the case of this person, what was her annual salary?
Which person? Mrs. Bevans?
Yeah, Ms. Bevans.
Yeah, certainly well in excess of that.
Yeah,
But it's
and,
the one, it's the.
But can I ask you another question? In a corporate structure and a statutory board, what do you think is the intention of Parliament in creating a board in terms of public transparency, accountability, good governance? Is it that the board is supposed to be intended to be a rubber stamp to a minister, even though the minister appoints? Even though the minister appoints, is it that you know, in the judiciary, the monarch appoints judges, queens to the Queen's Bench and King's Bench, and I believe when they are appointed, they are not expected to be rubber stamps. I think so. I'm just wondering, how do you see this intention of Parliament with the creation of a statutory board in our jurisdictions?
Well, where there are instances requiring that for the conduct of particular business of the board and the making of particular decisions, there ought to be formal meetings and minuted resolutions. The Act says so. If your
And
honors
would you think, let's just take this to the case. Would you think that, leave aside what you call the 8,000 under appointments, when you're making a substantive appointment to a person who's going to be basically the CEO, the director of tourism, this is the Tourism Board of Belize. This is the person who's going to run the show virtually, because the board, as we know, is operating at a different level. Would you consider that an appointment of sufficient significance for these different protocols, these maybe higher standard protocols to apply, or not?
No, Your Honor,
No.
because
Okay.
in my respectful submission, what is happening here is that the board, in effect, gives the chair and the vice chair. It's not just that there is a section that says that the decisions of the board may be signified under the hand of the chair and the vice chair. With respect to something like the approval of officers, be it at the level of director of tourism or at the level of the office assistant, the board cedes to the chair and vice chair the authority to act for the board and to make those appointments. It cannot be.
So basically, in your opinion, under Section 14, all appointments at whatever level, at whatever remuneration or terms and conditions are not matters that require board decision per se. That has been, in your opinion, that has been delegated to the minister to direct the chairman to act on.
No, I'm not saying that, Your Honor.
No.
I'm saying that the board decided, and that arises from the evidence, which made plain that the board was kept apprised of the negotiations that were taking place. There are minutes that said the board was made aware that the minister and the chair and the vice chair were looking after this matter, making it plain that that was with the approval, the authorization of the board. And that makes sense, Your Honor. These are the sorts of decisions, appointment of staff, that surely the board is entitled to say will be handled on our approval, with our authorization, by the chair and the vice chair.
Mr. Barrow,
sorry.
may I ask you, where is that point to be found in Section 14? That the board delegated its authority to appoint the CEO and director
it's
to
not,
the chair?
It's not expressly there.
Where is it expressed?
I'm sorry?
Where is it expressed?
No, it's implicit, Your Honor, and it's also when you read that section in conjunction with the section that says that the Section 8, the seat of the board shall be, the seal of the board, that should be a seal.
Section 8, you say, sir?
8.3.
8.3.
Section 8 deals first with the seal of the board. 2, the seal of the board. 3, all documents other than those required by law to be on the seal made by and all decisions of the board may be signified under the hand of the chairperson or deputy chairperson.
With respect, I'm not sure that
that
supports you. With respect, Mr. Barrow, I'm not sure that supports you at all. It's saying that the decisions of the board are signified under the hand of the chairman or deputy chairman. But clearly,
yes,
it is not the signing by the chairman or deputy chairman that constitutes the decision. It's a decision of the board, which can be evidenced by the signing by the chairman or the deputy chairman. That's how I read 8.3. Do you read it differently?
and Your Honor, and the fact that in terms of the appointments of officers, there is no express requirement for those appointments to be made by full meetings or by decisions of the full board taken in formal meetings with minuted resolutions. It is very telling. There's nothing where, if you look at the judgment at first instance.
Mr. Barrow, can we just pause for a minute about, so you are suggesting that whatever we decide in this case, that going forward, for good governance in Belize, the practices that you are describing right now are the best practices for the running of statutory boards in Belize. That for appointment of persons by a statutory board, irrespective of the remuneration package or status, including of a CEO, that there is no need for consideration by a board and or approval. And I think the president, you're not saying that. So which,
I'm not
in
saying
this
that.
case, which appointments would you say should come to this board for the board consideration and approval? Which appointments, if not of the CEO, which ones?
Well, all appointments come to the board in the sense that they come to the chair and the vice chair, who have the authority of the board to act for the board in that regard.
So, all right, so let's take it step by step. Therefore, you agree that as a question of law, the board must approve. But you say, in this case, that approval, so you accept that as a standard of governance under the statute. But you say, in this case, that approval is found in the signification by the signatures.
More than that, by the fact that on the evidence in this matter, it was clear that the board was aware of the fact that Mrs. Bevans' renewal.
But Mr. Barrow, awareness and approval are certain, I would think, qualitatively different. Approval requires, I would think, some information, some deliberation, and some decision. Being made aware of is a question of notification. You notify, so we know. Approval requires, I would think, certain elements. Now, so that's why I didn't think that's what you were saying. What I thought you were saying is to the president was that is it section 8? I forget now. Under section 8, the fact of the signature, but the president raised something that I didn't think you responded to, and that is signification. But signification of what? Of approval.
Yes. And
so you agree there must be board approval?
Yes, Your Honor.
Right.
I agree, but the board approval is not constituted invariably and inevitably
by the board
and axiomatically by a decision of the full board taken at a formal meeting where a resolution is carried.
Mr. Barrow, I'm looking at section 13 of the Act. I find it interesting because it deals with the power of the board to delegate, and it's by a majority, 2/3 majority vote. So it gives me the impression that this is something that is considered serious enough that there should be a vote of 2/3 of the members of the board. And this is to delegate to any member or committee of the board. So for example, if there is a human resources committee or financial oversight committee on the board, whatever power the board has, it has to vote to delegate that power to, let's say, a committee or a member. How do you see this operating, if at all, with respect to the fact that the chair and the vice chair, from how I understand the argument, you're saying that the power of the board is in some way given to them by virtue of, I think, section 14, you were saying?
I'm saying that indeed, under section 14, it is perfectly permissible in the absence of an express requirement that the decision of the board must be made via a formal resolution that's minuted. In the absence of that, it is perfectly permissible and consistent in terms of the practicalities of the situation that the board should delegate to the chair and the vice chair the power to execute on behalf of the board these contracts of employment. And that is what happened certainly in the Michael case. We learned from the evidence that at the same time, something like 5 such contracts were signed, all by the chair and by the vice chair. In no case was there any requirement, was it felt that there was any need for a formal meeting of the board and a minuted resolution.
Right. Okay. Well, I think we could probably move on.
President,
from
before
there.
we move
But
on.
yes, I just wanted to one question before you do, Judge.
Yeah.
And that is that, Mr. Barr, you would concede, though, that it is possible for the chair and deputy chair to act in a way that the board as a whole has not approved. It is possible for the chair and deputy chair, for example, to contract with X, and the board has not approved the contract with X.
Well, that is possible, but the board.
Right. So the
would
mere
then-
fact then that the two persons, two principal officers here, chair and deputy chair, have acted in a particular way does not mean that the board approved. They're acting in that
Except that came back to the board, and the
Right.
board signified its unanimous endorsement and approval.
Right.
So
But
in
at
a sense-
what point in the continuum did that happen? I think part of the difficulty, the suggestion is that the board ought to have approved before the contract was entered into.
No, Your Honor. The minister needed to have approved before the contract was entered into.
And the board didn't need to approve. I think that's the
board, after the minister approved, then the board would make the appointment via, in this case, the chair and the vice chair. And I think that was the point that Mr. Justice Ibo Osuji was making. Look.
Okay. Yes. Sorry.
If Your Honor, to me, the key, the answer to all this lies in this court's decision in Warrington. And I wonder if.
Well, I think my brother wanted to ask you a question first, but I'm glad you're prepared to move on because we have been here a long time on this point.
All right, President, it's
yes.
okay. We can move on.
Okay. Yes, Mr. Barr, you're going to move on to, is it Warrington?
Yes, Your Honor. I believe the court is familiar with the facts of Warrington, where there was a requirement for the advice and approval, as it were, of the Prime Minister before Mrs. Warrington could be reappointed as General Manager of the Broadcasting Authority. And I would ask the court to look with me at paragraph 14 of the judgment of Mr. Justice Barrow. This is at tab 3 of the master index, where he said there was no discussion in the judgments or the submissions of what constitutes the advice of the Prime Minister. The expression does not appear to be used in any technical or specialized way. The expression seems simply to refer to a communication or indication from the Prime Minister. In its context, there is no reason to think that it requires the Prime Minister to initiate the process of identifying a candidate. In an everyday bureaucratic or institutional way, the natural thing would be for the board, as they did in this case, to advertise for candidates and shortlist suitable persons for the Prime Minister to select one. Or the Prime Minister could know a suitable person and advise or communicate that this was his choice, or the board could itself select a candidate and ask the Prime Minister to advise if he approved that candidate. The point is, as I believe Mr. Justice Ibo Osuji was saying, under the section, there is absolutely nothing wrong with the minister making the selection. And if you look at the evidence, when the minister was cross-examined, he said he made the selection and then he instructed the chair and the vice chair to get, in effect, the board to execute the contract. He didn't make the contract. And this is where I think there is the divergence between the position of my learned friend and ourselves. It is not that the board did not make the contract, and it certainly is not that the minister made the contract. He made the selection, and that under Warrington is perfectly in order. Even after the Prime Minister
He did more than
that
the selection, though, Mr. Barr, didn't he? Didn't he agree the terms of the contract? Did he negotiate the terms of the contract?
Who?
It's not just electing the contractor.
The Prime Minister in Warrington?
No, I was thinking of the Bevans case.
Yes, and he is entitled to do that. Ultimately, the board then has to make the formal appointment. But again,
but hold on, Mr. Barrow. That you see, you say ultimately. I think that's very important. What you say, so the minister makes a selection, the minister can negotiate the terms, everything you say, and I quote: ultimately, the board must make the decision.
Indeed, indeed.
That equates to board approval. Agreed?
Yes.
All right.
Yes.
I don't want to go back over the ground we've covered because the president is going to take off my microphone and he'll be perfectly justified in doing that. I want to ask you something to move us forward. If we determine that there was no board approval, I know for you this is hypothetical.
Right,
If we determine there was no board approval, what is the consequence?
Well, if you decided there was no board approval, I would want to ask whether that would be a decision that there was no board approval, period, or that there was no board approval until after the chair and the vice chair executed the contract.
Are you referring to the applause part of the narrative? We were told, in other words, so you are saying that there is no distinction between approval and applause. The applause could constitute the approval. Is that what you're saying?
No, Your Honor. I'm sorry that Your Honor surely.
No, I'm just reciting the narrative that we were
told. You do me an injustice if.
Sorry,
if
I
the
apologize.
Suggestion is, no, I am saying that there was approval after the chair and the vice chair executed the contract in two ways: by the unanimous acclamation approval of the board, its congratulation of Mrs. Bevans on the new contract, and its performance of that contract.
All right.
For almost 2 years.
So we have all of that. What I'm asking you is, if we decide there is no board approval, I know you say there is, and you've told us why, but if we decide there is no board approval, what is the consequence?
Your Honor, I'm afraid you have me stuck because I don't see how there can not.
Well, I will leave you in the president's hands. President, I will surrender this part of the narrative to you.
I was wondering, Mr. Barrow, whether ostensible authority would not come to your rescue in that case.
Absolutely.
Yes.
Absolutely, it would. And but before I get to that, if I can go back to Warrington and paragraph 22. When therefore the Prime Minister accepted Mrs. Warrington's appointment by at least acquiescing in her continued performance in the position of manager, there was practically nothing really left for the Prime Minister to do. The board was no less acting on the advice of the Prime Minister because the advice came by way of acquiescence in an appointment that had already commenced. It does
Sorry,
not
this is
affect
on paragraph again, please. Sorry.
22.
22. Yeah, thank you.
It does not affect the validity of the advice because it was or may have been given retroactively. And that's my point. Even if we get hung up on the question of whether the board as a full board, by way of a formal meeting with a resolution that was ministered, even if we get hung up on the fact that that did not happen, that does not mean that there was no approval, because approval could come after the execution done by the chair and the vice chair. There could be, as Warrington makes plain, retroactive approval.
But to approve it even retroactively, Mr. Barrow, you'd have to know the terms, wouldn't you? That's, I think, one of the points that Mr. Courtney was making, that if at that point of the applause, you were going to investigate what the terms were.
But Your Honor, surely that is, in a sense, not a red herring, but as was made plain, the board applauded, the board approved, the board is in control of the day-to-day running of the corporation. The board is in control of the budget. The board knows or can and confirm at any time what the terms and conditions governing the contracts of all employees, what those terms and conditions are. So to say that
they would be presumed to know. They were presumed to know, if not.
Yes, indeed, Your Honor, because how could they not be presumed to know when they run the corporation? And in fact, it was put to them, this thing has been approved, and they said hallelujah, and they congratulated Mrs. Bevans. And if there was any single dissenting vote or any single seed of doubt planted in anyone's mind, there would not have been that unanimous acclamation. And if there was any concern about every I and every T with respect to the contract that the chair and the vice chair had executed, it was the easiest thing in the world for any member of the board to call for the contract and to go over it line by line. It
a done deal by then, though, Mr. Barron. It was a done deal. Fait accompli, a done deal by then, you know. And when you're in church, you know, and everybody applaud, it doesn't mean that everybody has heard what the preacher said.
No, but then, and so if there was not, in fact, unanimous support for and endorsement of, then somebody would have said something. Your Honor, again, the whole question of the evidential burden, it is for the other side to show that there was no approval, and they brought no evidence. I'm sorry to keep coming back to Carl Sagan and his famous quotation that the absence of evidence is not evidence of absence.
I'm not sure, Mr. Barrow. I'm not sure that Carl Sagan's quote helps you there. Maybe you're better off with the traditional conception you started with, equia falat incumbit probatio. He who proposes must prove, and they proved that there was irregularity.
Precisely.
So, nonetheless, we enjoyed the surgery into that territory. May I ask you though, Mr. Barrow, is there any distinction in your view between your argument that there was in fact approval by the board and the issue of ostensible authority? Are they conceptually, doctrinally different? Are those separate grounds? Or are they same?
Yes, they are. Yes, conceptually they are.
Please.
We say, first of all, that there was approval, and if you will allow me just to conclude on that question of retroactive approval, again at paragraph 22, when Mr. Justice Barrow said the board was no less acting on the advice of the Prime Minister because the advice came by way of acquiescence in an appointment that had already commenced. It does not affect the validity of the advice because it was or may have been given retroactively. The unexceptional nature of this proposition is shown in Whitfield against the Attorney General of the Bahamas, where the validity of the continuation in office of the Chief Justice was challenged. The government had accidentally failed to comply with constitutional requirements in time to obtain the Governor General's permission for the judge to continue in office before the date of his retirement. An instrument formalizing the grant of permission was issued some weeks later and stated the permission took effect on the retirement date. The challenger argued that permission to continue in office could only be given while the incumbent held office. After he had retired, he could not continue. He had ceased to hold office as the effect of the retirement. 23, although it did not form part of the reasoning for dismissing the challenge and the subsequent appeal, it is interesting to note the determination of the first instance judge that the government could appoint a servant of the state with retroactive effect. His lordship decided that neither the general law nor the constitution prevented it, and as well there was no requirement for the Governor General's permission to be given in writing. That view on the validity of a retroactive reappointment to one of the highest constitutional offices supports the idea that the appointment of the manager of a statutory corporation may be validated by the retroactive approval of the Prime Minister. In this case, the retroactive approval of the board. The case is also persuasive against the corporation's submission that Section 66B of the Broadcasting Act should be interpreted to mean that the advice of the Prime Minister should be in writing. Well, again, I think we've already dispensed with that. There was no need for writing. And then finally, Your Honor, if I could just make the point that Warrington went into this whole question of narrow ultra-vires and wider ultra-vires, and the question of a condition precedent. And Mr. Justice Barrow made the point again that the corporation in paragraph 31, the corporation is established by Section 3 of that Act, and Section 4.1 states that the corporation shall be managed by a broadcasting board consisting of a chairman, a deputy chairman, and such other members, and so on. There follows provision as to the qualifications of the persons whom the minister may appoint, termination of appointments, and so on. Then comes Section 66, which provides for the board to appoint officers, including a director of broadcasting. Your Honors, I'm sorry if I can just skip ahead very quickly. I know my time is running out at paragraph 34. It is apparent that the requirement of the Prime Minister's advice for the appointment of certain officers of the corporation was not directed to the structure, functioning, administration, or powers of the corporation. The requirement for the board to act on the advice of the Prime Minister was a staffing requirement directed at ensuring that the board could only appoint persons selected or approved by the Prime Minister. It ensured that no person whom the Prime Minister found objectionable or unsatisfactory could be appointed. I come back to Mr. Justice Ivo Osuji. We perhaps sometimes are looking at this the wrong way around. The the minister selected, the board had to appoint, but the board could not, as was said in Warrington, if the board of the broadcasting authority there had refused to make the appointment following the prime minister's selection of the person to be appointed, that board would immediately be fired. And so on top of this, Parliament imposed a requirement that this politically appointed board could only appoint a general manager upon the advice of, meaning selected by, or at least with the approval of the Prime Minister. I think, Your Honors, I insist that we get too caught up with the question of the minister in this case having been clear that in his view, he did the selection, and that once he did the selection and he instructed, and we must look carefully at what his instruction to the chair and the vice chair was, to get the board to appoint, to execute this thing, get the board was to execute, not the minister. Once there is that, and the board, in fact, executed the appointment either via the chair and the vice chair properly because they had known that they had left it in the hands of the chair and the vice chair to work it out, or retroactively, even if the court disagrees that they had given a priori that confer that authority on the chair and vice chair, even if they then approved it retroactively, that was fine. It is inconceivable that the board would deliberately purport to make an appointment that was not, in this case, approved by the minister. Such a wayward and defiant board would presumably have been summarily fired. And so in real world terms, that's what it came down to. And then finally, Your Honor, very finally, at 36, when the court deals with this question of a failure to satisfy an alleged requirement of formally obtaining the prime ministerial advice, in this case, of formally getting a resolution minuted of the board's approval of the selection. Would that have been intended by Parliament to result in invalidity? That is the principle that Mr. Justice Barrow went on to discuss under the rubric, the effect of non-compliance. And of course, he then went into blue sky. It used to be that a distinction was drawn between mandatory and directory provisions and this enabled courts to conclude that failure to comply with a mandatory requirement made the exercise of power void, whereas failure to comply with a directory requirement made the action unlawful but not void. In Project Blue Sky, the majority of the High Court of Australia referred to this distinction and the uncertainty that attended it. The Honours endorsed the criticism of the use of the elusive distinction between directory and mandatory requirements, and the division of directory acts into those which have substantially complied with a statutory command to those which have not. They stated, they are classifications that have outlived their usefulness because they deflect attention from the real issue, which is whether an act done in breach of the legislative provision is invalid. Classification of a statutory provision as mandatory or directory records a result which has been reached on other grounds. Classification is the end of the inquiry, not the beginning. A better test for determining the issue of validity is to ask whether it was a purpose of the legislation that an act done in breach of the provision should be invalid. In determining the question of purpose, regard must be had to the language of the relevant provision and the scope and object of the whole statute, which in this case was to appoint a director of tourism. The observation was also made that the courts have always accepted that it is unlikely that it was the purpose of the legislation that an act done in breach of a statutory provision should be invalid if public inconvenience would be a result of the invalidity of the act. if the court takes the view that there was non-approval of the board, before we get now to the question of the acclamation and the retroactive approval, in that period, then the result of the invalidity of the act would have been tremendous public inconvenience and public mischief. There would have been a non-appointment. There would have been a non-filling of the role of director of tourism. The correct modern approach to procedural requirements is for the courts to focus not on literal classification, but on rather what should be the legal consequence of non-compliance with a statutory or regulatory provision. The good sense of the modern approach invites a similar conclusion in the present case. It is unlikely that it was the purpose of Parliament that a failure to obtain the formally conveyed advice of the Prime Minister to renew the appointment should result in its invalidity if no purpose would be served by the consequence of invalidity.
Mr. Barrow, Mr. Barrow, I must advise that your time is almost up. I gather you, Mr. Barrow, agree with Justice Barrow, and that is fine. But if you want us to read things from our brother after the hearing, we're happy to do that. I don't know whether you wish to use the remaining 2 minutes to continue in this vein or not.
Well, I would just use it to say that
Yes.
I would take up Mr. President's point regarding the question of ostensible authority as a fallback. At the very least, there is no question. I was a little bit flabbergasted, befuddled, when I believe I saw something from my learned friend suggesting that the chair and the vice chair were not agents of the board, could not have ostensible authority from the board. They had ostensible authority from the minister. With respect, Your Honors, that makes no sense at all. They were clearly acting as chair and vice chair of the board. And on the basis of the practice and all that had happened, all those contracts that had been signed by them almost contemporaneously, it is quite clear that they were, at the very least, had ostensible authority, that anybody who was not an insider would be obliged. It would take a great deal of cognitive dissonance to try and rationalize any argument that the chair and vice chair were not agents, not ostensible, not agents, and therefore did not have ostensible authority of the board vis-a-vis Mrs. Bevans.
I follow you very clearly on that. I suspect my colleagues do as well. For me, the troubling aspect has to do with the nature of Mrs. Bevans as an outsider, because that is necessary in order for this ostensible authority doctrine to apply. Now, I gather Mr. Courtney is saying that Mrs. Bevans was the CEO and also the director. And he's saying that you can't get any more insider than that. So could you address that, please, in a couple of minutes that you have left, if you don't mind?
Well, Ms. Terinka, you wanted to say something about that? Could I ask Ms. Terinka?
Of course, yes, absolutely. Thank you.
Your Honors, we submit on that point that Ms. Bevans is not a member of the board. She is an ex officio member, and this is stipulated in the judgment of the Court of Appeal, page 22. It says that she is not a member of the board, and it also leads into the question of fairness, because we heard Mr. Courtney's submissions that she would be the quintessential insider.
Yes.
However, here, even the court below and the Court of Appeal recognize that there seemed to be a bit of ambiguity as to what were the proper procedures. And the Court of Appeal commented the board should consider making regulations, which it has the power to do, so that the procedure is made clear to the board, the minister, and the chairman and vice chairman. So I believe the other side is putting all the burden on Mrs. Bevans, that all that she had to do was to read the act. However, the court recognized this, even in the High Court and the Court of Appeal, that there was ambiguity as to the proper procedure. So we want to elaborate that it must be borne in mind what is fairness, and was that fair to Ms. Bevans, that she is supposed to know what is a proper procedure when the board itself didn't seem to have it clear what was the proper procedure. These arguments, of course, are in the alternative, because we're saying that the board did approve, but there do seem to be some ambiguity as to what was the correct procedure. And the evidence before the court is that the board itself might not have had it so clear. So it's not so clear cut.
Yes.
The other point that we want to raise is that the resolution is not required, because the court in the High Court set out provisions that stipulate where it is required. And in this section 14.1, there is no requirement for a resolution of the board. So we say that it does not apply because it was not included. So we bring to the court's attention paragraph 24 of the High Court's judgment, page 1184 of the record, where the court says that
Sorry, I think the time has gone, so we will note, respectfully, we'll note the place where we should read that quotation, and we'll do that later.
much obliged, Your Honors.
Thank you so much. Mr. Barrow, any final word? You're muted once more, sorry.
I'm sorry, Your Honor. No, I hope that I have, in fact, fully delivered myself of all that I needed to.
Thank you very much, Counsel. Mr. Courtney, it's well past our lunchtime on this side of the Caribbean Sea. I don't know. I think you're entitled to 20 minutes for a reply.
Mr. President, I was hoping to take 10.
Ah, that's wonderful. Wonderful. Thank you.
Could I start by flabbergasting my learned friend again?
There. Yes.
The evidence before the court, not my submissions, the evidence before the court from the minister and the chairman is that the board has no role to play in the appointment. The evidence is that it is the minister who is to make the appointment. That is the evidence. It does not lie in the mouth of my learned friend to now say, notwithstanding that, the board approved. Your Honors, where you have a chairman of the board saying in sworn evidence that it was for the minister to approve and not the board, which is what he specifically said, why would that chairman then go to the board after he had executed the contract and say, I now come to you for approval? He's operating on the basis that the board is not required, approval is not required, the minister's approval is required. I have received his approval, I have signed it. I am merely informing you what has happened. That is what the evidence leads to. So, with the greatest of respect, Your Honor, my learned friend said the approval came after what the contract was executed by acclamation and performance of the contract. With the greatest of respect, that is contrary to the evidence of my learned friend's witnesses.
But Mr. Courtney, you did accept that after the deal was done, I believe in your submission to say that the board was told and the board applauded. Isn't that applaud? Doesn't that equate acclamation? Doesn't that equate ratification
Your Honor, the evidence,
retroactively.
I can only go on the basis of evidence. My first point is the chairman and the minister expressly have said that board approval was not required.
Yes,
The
but
evidence,
they did a claim or applaud
the
after
evidence,
they were informed, yes.
the evidence is that everybody was satisfied with Mrs. Bevans's performance. My submission to the court is this, and I'm repeating myself. The inference that Justice Ibo Osuje is urging on me, or raising, I should say.
I'm not urging, I'm just
Right.
approving your question.
Raising. That when the chairman went to the board, he was going there to seek ex post facto approval, requires us to disregard his sworn testimony that that was not required. So he went and he said, guys, guess what? The minister has done it. I have signed it. Let's all clap hands and kumbaya. He was not asking them to approve it because he believed that it was not required. I have repeated that a number of times. Those are my submissions. Your Honor, I ask you to look at the minutes of the board, page 256 through 385. You will see repeated resolutions by this board. My learned friend, Ms. Munoz, says the Court of Appeal identified the sections of the law when resolutions were required. Well, the board made dozens of resolutions in relation to matters not covered by those sections. And the reason for that is very clear. Because Section 9(5) of the BTB Act says decisions of the board are to be by majority decision, and 9(6) says they're to be minuted. That is what good governance requires, taking decisions by majority, minuting it in the board. In the minutes.
Mr. Courtney, we hear you. I think a combination of comments from the bench, perhaps comments from Mr. Barrow on the other side, really amount to the following, that we are dealing almost with a technicality, because it is unimaginable that had the matter gone to the board in the way you are saying it should have done, that the board would not have approved. And therefore, what we are doing is arguing over, in effect, a technicality. How would you respond to that?
I am very glad that you raised that, Mr. President. It is the quintessential argument made in public law. That is, you challenge a decision by a decision maker. You prove that the decision maker acted ultra vires. The court never says, yeah, well, don't worry about it. That's fine. No, the court quashes the decision, remits it to the decision maker or to another person to make the proper decision. It is not, with the greatest of respect, a technicality for a minister and a chairman to make a decision that commits a board to more than $1 million in expenditure without the deliberation and decision of the board. It is contrary to good governance. It is contrary to Section 14. It is contrary to the duty of the directors to approve the appointment of the chief executive officer of this corporation. And Your Honors, if there is non-compliance, there are two options. One is you do it over. That is what public law requires. The proper person takes the decision. And Your Honor, I cannot say that had the board addressed its mind to the section, it would not have approved it. In all likelihood, I would have to consider, in all likelihood, that is what would have happened.
Yes.
What we're dealing with, however, is a different board, lawfully appointed, coming to court and saying there has been none compliance, and we do not approve. We do not approve. And I'm saying that that is what the court is confronted with. An ultra vires
Help me with
decision.
something in that regard, Mr. Cutnet, please. I'm looking at Section 7 of the Act. And Section 7 says the board has perpetual succession. Yes, we mean perpetual succession means it doesn't die. But doesn't it also entail the idea of business continuity, that a previous regime has done something a subsequent regime is expected to carry it forward, unless, of course, there is some very overwhelming reason to say no, that cannot be the case. Perhaps that's your argument. But perpetual succession, what does that mean? Doesn't it require a board to implement what the previous board has done?
Your Honor, respectfully, I do not understand perpetual succession to connote that at all. Perpetual succession is, as you say, it lives forever until this act is repealed. Your Honor, with the greatest of respect, and there are many, many, many cases on this. This exists at every level of our democracy and life. Boards, governments change. This court in particular has had several cases from Belize where there has been a change of government and a new cabinet comes in and say, we have reviewed the previous contract, we have reviewed the previous concession, we do not agree with it, we are now challenging it. And the court—
Yes, definitely. When we have a clear case of bad faith, no one will say, well, in the presence of bad faith, you have business continuity. But you're not arguing bad faith.
Your Honor, I am not talking about bad faith. I'm talking about something even stronger. I am saying ultra vires. The person empowered with the power to make the decision. The board did not make the decision. The decision was made by the minister. He had no authority to do so. Can I just make my final point?
Yes, please.
A relatively small point. And this is a question of the status of Mrs. Bevans. Her evidence at page 1066 is that she attended all meetings of the board unless she was traveling. Your Honors, Madam Justice Roger Lee already picked up the point which I was going to make. That section 13 is the section that provides for the delegation. My learned friend was running an argument that the chairman and vice chairman were authorized. In order for that to happen, they have to be a 2/3 resolution by the board to authorize them to do that under section 13. And obviously, again, Mr. President, you dealt with it. As we have said in our written case, section 8 of the act is not a section that empowers the chairman or the deputy chairman to do anything. Decisions must be taken by the board and then they merely signified by their signature. It is not empowering them to make decisions. Your Honors, I believe those are the points I wanted to respond to. Unless I can give further assistance, those are my submissions.
Thank you very much, Mr. Courtney. And you finish exactly at 3 p.m. Late lunch for us, but regular lunch for you, I'm sure. I think that's it. Thank you very much indeed, Counsel, for your arguments. Very enlightening, and it was a joy to hear from both of you. We naturally will consider the arguments you have placed before us, and as soon as we're able, we'll indicate when it is that we'll give our decision, and then we'll give the decision on the date indicated. Thank you very much indeed.
Much obliged.
Thank you, Mr. President and members of the court. Thank you.
Thank you, sirs. Madam Deputy Registrar, would you please close the proceedings?
Certainly. Thank you, Mr. Justice Winston Anderson, President. Thank you, Madam Justice Rajnakley. Thank you, Mr. Justice Jamada. Thank you, Madam Justice Honorable. Thank you, Mr. Justice Ebowasuji, and thank you, Counsel. Despite all the technical difficulties, as the President said, we were grateful to have you with us today. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.
Thank you very much.